Please be seated. The sitting is open. La Cour se réunit ce matin pour entendre la Namibie, la Norvège, Oman, le Pakistan, l'Indonésie et le Qatar sur les questions soumises à elle par l'Assemblée générale des Nations unies relatives aux conséquences juridiques découlant des politiques et pratiques d'Israël dans le territoire palestinien occupé, y compris Jérusalem-Est. Permettez-moi de rappeler que chaque délégation doit respecter le temps imparti pour sa présentation, qui est de 30 minutes. Ce matin, la Cour observera une brève pause après la présentation de Oman. I shall now give the floor to the representative of Namibia. Honorable Mrs. Yvonne Dossab, you have the floor, Madam.
Mr. President, Madam Vice President, members of the Court, it is a special honor to appear before you today on behalf of the Republic of Namibia. With your kind indulgence, I wish to first pay tribute to our late President, Dr. Hage Geingob, who passed away on 4 February 2024 and will be laid to rest this weekend. President Geingob was a key figure in our struggle for independence. He was a committed anti-apartheid and anti-colonial freedom fighter who stood up against injustice and oppression wherever it occurred. It is therefore fitting that in one of his last public statements, he said that no peace-loving human being can ignore the carnage waged against Palestinians in Gaza. President Geingob was the representative of SWAPO and its petitioner to the United Nations from 1964 to 1971. It was during this period that the General Assembly condemned and declared the policies of apartheid and racial discrimination as a crime against humanity. Consequently, the General Assembly also appropriately terminated the mandate in Southwest Africa. Mr. President, members of the Court, I stand before you as a representative of a country where Germany brutally carried out the first genocide of the 20th century against the Herero and the Nama peoples. A country that has known only too well the pain and suffering of occupation, colonialism, systematic discrimination, apartheid, and their entrenched consequences. It is because of this history that Namibia considers it a moral duty and sacred responsibility to appear before this court on the question of the indefensible occupation of Palestine by Israel. The parallels between Namibia and Palestine are striking and painful. Both were integral parts of the mandate system established after World War I, and in both cases, the so-called sacred trust of civilization, which aimed to guide these nations towards self-determination and independence, was utterly betrayed. Instead of achieving self-government, both Namibians and Palestinians suffered the loss of human dignity, life, liberty, and the outright theft of their land and natural resources. Hundreds of thousands of their people were violently expelled from their homes or forced into exile, joining the ranks of the world's refugees. Upon the dissolution of the League of Nations in 1946, the white minority South African regime refused to place Namibia, then Southwest Africa, under the UN trusteeship and sought to illegally annex our territory as a fifth province, implementing racist homeland policies and apartheid laws targeting Black Africans. Today, Palestinians have had to endure the seizure of their land and property, illegal settlements, unlawful killings, forced displacement, drastic movement restrictions, the denial of refugees' right to return, and of equal nationality and citizenship. The lived reality of the people of Palestine evokes painful memories for many Namibians of my generation. Namibians still experience the entrenched and structural impact of inequality as a direct consequence of colonialism and the prolonged unlawful occupation. Mr. President, members of the court, this court's 4 advisory opinions on Southwest Africa played a vital role in our liberation struggle. In its 1971 opinion, the court confirmed the right of self-determination as a legal imperative with decisive consequences for states, paving the way for our independence 19 years later in 1990. It is because of Namibia's experience with apartheid and its long fight for self-determination that we cannot look the other way in the face of the brutal atrocities committed against the Palestinian people. Mr. President, members of the court, we ask you not to look away either. Rather, we appeal to you once again, end the historic and ongoing injustice by upholding the fundamental rights of a dispossessed people who have endured 57 years of a suffocating occupation. Today, Palestinians are enduring collective punishment in the besieged Gaza Strip, with civilians being killed in continuous and indiscriminate bombardments at a scale that is unprecedented in recent history. This state of affairs, this hell on earth, represents a stain on the collective conscience of the world. Civilized nations cannot and must not accept images of children covered in blood with gaping wounds, of men and women crying in despair because of the helplessness they feel. However, in the midst of the ongoing tragedy, I wish to say the following to the people of Palestine. This advisory opinion is an important moment in your long fight for independence. And I leave you with the words of our founding president and father of the Namibian nation, Dr. Sam Nujoma. A people united, striving to achieve a common good for all members of society, will always emerge victorious. End of quote. Mr. President, members of the court, I thank you, and I now respectfully ask that Professor Phoebe Okoa be called to address the legal questions before the court.
I thank Mrs. Dosab. I now give the floor to Professor Phoebe Okoa. You have the floor, Professor.
Mr. President, Madam Vice President, members of the court, it's a great honor for me to appear before you in these proceedings and a special privilege to do so on behalf of the Republic of Namibia. Our presentation is in 3 parts. First, I will make 2 general observations on why the court should answer the request in its entirety and why Israel's occupation is illegal. Then I will focus on Israel's policies and practices in the occupied Palestinian territory that grossly violate its obligations under international law, specifically the prohibition of apartheid and racial discrimination and the principle of self-determination. Finally, I will address the legal consequences that arise for Israel, for third states, and for the United Nations on account of these violations. As a threshold matter, Namibia reiterates, as do the overwhelming majority of states in these proceedings, that the court has jurisdiction to render the requested advisory opinion and that there are no compelling reasons for the court to decline the request. Namibia notes that there is also wide consensus among the participants on the legal status of the occupation. Namibia makes only 4 brief observations. First, insofar as the law of occupation envisages any belligerent occupation as a temporary measure immediately following military operations, Israel's prolonged or permanent occupation breaches the law of occupation. It is a de facto annexation in all but name. Second, Israel's occupation in and of itself is unlawful under general international law. This is because it violates the Charter of the United Nations and peremptory norms, specifically the prohibition on territorial acquisitions through illegal use of force, the principle of self-determination, and the prohibition of apartheid. Third, successive resolutions of the Security Council and the General Assembly have declared Israel's occupation to be illegal and called on Israel to end it immediately. These resolutions provide an independent source of authority for the illegality of the occupation. Finally, the continuation of the illegal occupation does not absolve Israel from its obligations and responsibilities under international law. This is consistent with your own conclusions in the Namibia Advisory Opinion that physical control over territory and not sovereignty or legitimacy of title is the basis of state liability for acts affecting other states. In both its written and oral submissions, Namibia focuses on the prohibition of apartheid and of racial discrimination. This is in part on account of Namibia's history as one of the few countries that was subjected to this egregious form of systematic and institutionalized racial discrimination. We also do so on account of the fundamental importance of the court's 1971 Namibia opinion, where this court declared that the policies of apartheid constitute a denial of fundamental human rights and are a flagrant violation of the purposes and principles of the United Nations Charter. But above all, we do this because, notwithstanding the egregious nature of apartheid as a state delict, as a violation of a peremptory norm, and as a crime, it has received virtually no clarification beyond the specific circumstances of Southern Africa. An advisory opinion on threshold questions of apartheid will therefore assist the General Assembly in respect of its own action in identifying the key elements of the illegality and in formulating appropriate responses to Israel's discriminatory practices in the occupied Palestinian territory. Specifically, we invite the court to clarify 3 aspects of the obligation. First, we respectfully ask the court to make it clear that the prohibition of apartheid is not limited to Southern Africa in the last century. It extends to Israel's policies in the occupied Palestinian territory today. Article 3 of SAD places all state parties, including Israel, under an obligation to prevent, prohibit, and eradicate apartheid in territories under their jurisdiction. This is also the conclusion of the SAD Committee. The 1998 Rome Statute of the International Criminal Court, negotiated after the end of apartheid in South Africa, also recognized apartheid as a crime against humanity without temporal or geographical restriction. Second, the court should also confirm that the prohibition of apartheid binds all states as a peremptory norm. In your decision, in the case under SAD brought by Qatar against United Arab Emirates, you acknowledged the universal character of SAD is confirmed by the fact that while 82 states are parties to it. The International Law Commission and its Special Rapporteur on Youth Cogents, as Judge Tladi then was, has also expressly recognized the peremptory character of the prohibition of apartheid. Finally, Namibia invites the court to clarify the definition of apartheid. Namibia aligns itself with other participants that the definition in Article 2 of the Apartheid Convention incorporates the three key elements of the delict under international law. First, the state must engage in one or more inhumane acts. Crucially, these take the form of violations of fundamental human rights within an institutionalized framework of systematic oppression and domination. Second, these inhumane acts must be directed against a racial group or its members. Finally, the state must commit these inhumane acts for the purpose of establishing and maintaining domination by one racial group over the other and systematically oppressing them. Other participants have already made extensive statements on the discriminatory and inhumane acts carried out against the Palestinians as a racial group. These policies and practices are too many to enumerate in the time available. They include laws that discriminate in matters of citizenship, ownership and transfer of property, and freedom of movement. The systematic and excessive use of force against Palestinian civilians, the arbitrary killings and mass incarceration of Palestinians, including children, the illegal settlements, the discriminatory residency regulations, and crucially, the denial of a Palestinian identity by refusing to recognize them as a people with a right to determine their own political destiny and to pursue social, economic, and cultural development. Namibia's submission will focus on the final requirement, the purpose of establishing, maintaining domination and systematic oppression. First, the term domination signifies a pervasive, all-encompassing, serious form of control over a group. Second, oppression implies prolonged cruelty, reflecting a sustained violation of human rights. Third, systematic implies the organized nature of violent acts and the improbability of their random occurrence. Namibia shares the view of other participants that Israel's policies and practices meet the evidentiary standard for establishing the state delict of apartheid. The Israeli government's openly articulated aim is to ensure Jewish-Israeli control of all facets of Palestinian life, as evidenced by legislation affirming Israel as the nation-state of the Jewish people, with unique self-determination rights reserved for Jewish individuals only. It is clear from all the available evidence that these discriminatory practices are not accidental or fortuitous, but are designed for the specific purpose of privileging Jewish Israelis over Palestinians. The fact that the practices in question may have other collateral objectives, such as maintaining security, is irrelevant. It will suffice if the primary motive is discriminatory, even if it also serves ancillary purposes. It follows in Namibia's submission that Israel's policies and practices are inconsistent with the prohibition of apartheid as a state delict under international law. Furthermore, these discriminatory practices in the context of prolonged occupation of the Palestinian territories violates the right of the Palestinian people to self-determination. As other participants have highlighted, these discriminatory policies and practices are directed at fragmenting the Palestinian people. These elaborate systems of administrative controls undermine group cohesiveness by dividing the Palestinian people into a number of administrative domains or groups with varying degrees of rights. This strategic fragmentation of the occupied Palestinian territory into Bantustans makes Palestinian life burdensome and in many cases unbearable, forcing them to leave their homes. Perhaps the epitome of discriminatory laws negating the Palestinian right of self-determination is the 2018 Basic Law, passed with constitutional status, which boldly declares that Israel is the nation of the Jewish people and that Jewish settlement is a national value. I will now turn to the final part of my submission. I will first examine the legal consequences of Israel's violations, irrespective of the status of the occupation. Second, I will examine the legal consequences arising out of the illegal status of the occupation. First, Israel must bear consequences for its violations. This is the most elementary requirement of the law on state responsibility. As others in these proceedings have highlighted, this includes the obligations of secession and the duty to make reparation for more than 5 decades of harms inflicted on the Palestinian people. The government of Israel has a legal duty to dismantle all the vestiges of systematic racial discrimination and oppression that permeate all aspects of Palestinian life in the occupied territories. As the State of Palestine itself said on Monday, Israel must bring to an end the annexation of Palestinian land, dismantle existing settlements, and recognize the right of the Palestinian people to self-determination in a viable state of their own. Second, states are under an obligation not to recognize Israel's breaches of peremptory norms of general international law vis-à-vis the Palestinian people. At the same time, the obligation of non-recognition is matched by a parallel and positive duty of recognition of the Palestinian people's right to self-determination realized through a viable and independent state of Palestine. Here, we ask the Court to pay particular attention to the historical context of these proceedings. Admission to the United Nations, unlike the League of Nations, was not automatic. It was conditioned on the state accepting to uphold the values and principles contained in the Charter, including self-determination. The admission of Israel was no exception. In the Wall opinion, you observe that when Israel proclaimed its independence, it did so on the strength of the partition plan resolution of the General Assembly. As is well known, that plan envisaged two states, one Arab and one Jewish. The Israeli Declaration of Independence makes this plain by recognizing, and here I quote, the natural right of the Jewish people to be masters of their own fate, like all other nations, in their own sovereign states, unquote. If that logic applied to the self-determination and statehood of the Jewish people, it must, by the same token, also apply to the self-determination and statehood of the Palestinian people. We further ask the court to consider whether there may be circumstances where political discretion in matters of recognition gives way to a positive duty of recognition, especially when it is necessary to safeguard a peremptory norm. And here, Namibia aligns itself with Jordan's written submission that all states are also under an obligation to recognize the right of the Palestinian people to self-determination, including by exercising that right within a viable and independent state of Palestine. Since Israel's policies and practices violate peremptory norms of international law, the occupation itself is unlawful. This entails consequences for Israel, for third states, and for the United Nations. In the Namibia opinion, you already set out the legal consequences of unlawful occupation. There, you said that once the court is faced with an illegal situation, it would be failing in the discharge of its judicial functions if it did not declare that there is an obligation, especially upon members of the United Nations, to bring the situation to an end. In that opinion, you recognize the clear obligation on South Africa to put an end to the illegal occupation and withdraw its administration from the territory. The same consequences must of necessity attach to the illegal occupation by Israel of the Palestinian territories. Cessation cannot be contingent on external factors such as the successful outcome of negotiations, as pointed out by some participants in these proceedings. A withdrawal contingent on the outcome of political negotiations effectively gives Israel a veto over the future of the Palestinian people. Namibia invites the court to set a strict time limit within which Israel must be asked by the General Assembly to bring the occupation to an end without conditions. Failure to set a strict time limit has the perverse effect of being treated as a quiescence in the present occupation and permission for it to continue indefinitely. Of course, Israel has defied this court and ultimatums issued by the United Nations organs many times. But it is precisely for this kind of egregious violations of peremptory norms that a regime of countermeasures was contemplated in the now widely accepted International Law Commission draft articles on state responsibility. Equality before the law is a cardinal principle of the United Nations Charter. No state, not Israel, should be exempt from the comprehensive regime of sanctions. Moreover, Namibia reaffirms the position held by the majority of participants that all states are under an obligation not to recognize, assist, support, or contribute to the continuation of the unlawful occupation. This is also in line with your own settled jurisprudence. In the Wall opinion, you confirmed that obligations of third states include the obligation not to render aid or assistance in maintaining the illegal situation, that all states must refrain from all forms of assistance, including transfer of arms and political support, that de facto perpetuates the occupation. In Namibia's view, this means, in particular, that all states are under an obligation to ensure that companies under their jurisdiction or control do not trade in Israeli goods or with Israeli companies originating from or linked to Israel's illegal occupation. Mr. President, members of the court, I thank you for your kind attention. This concludes Namibia's oral submissions. Thank you.
I thank the delegation of Namibia for its presentation. I invite the next participating delegation, Norway, to address the court and call Mr. Christian Gerber to the podium.
Mr. President, distinguished members of the court, I have the honor to appear before you on behalf of the government of Norway in the present proceedings. Israel's occupation of Palestinian territory has continued since 1967. Recent developments give rise to the utmost concern. They include ongoing indiscriminate and disproportionate use of force and other measures in the Gaza Strip, as well as illegal settlements in the West Bank, including East Jerusalem. House evictions, demolitions, forced displacement and settler violence against the Palestinian population are aspects of the Israeli occupation. Such acts run counter to fundamental human rights, international humanitarian law, and the right to self-determination of the Palestinian people. They threaten the foundations under international law for the vision of a region where two states, Israel and Palestine, live side by side within secure and recognized borders. Against this background, an advisory opinion will provide essential and timely guidance to the international community. The atrocities committed by Hamas and directed from the Gaza Strip on 7th October 2023 constituted heinous and massive terrorist attacks. Repeated rocket attacks launched from Hamas and other groups in Gaza against Israel constitute violations of international humanitarian law due to their obvious indiscriminate nature. Individuals responsible for atrocities and other crimes must be held accountable. Those constituting real and imminent threats to the Israeli population and territory expose themselves as lawful military targets within the constraints of international law. This does, however, not justify any breaches of international humanitarian law, including by inciting or taking measures directed against the civilian population. Norway takes due note of the provisional measures indicated by this court on 26th of January this year. Mr. President, the Israeli settlements in the West Bank and East Jerusalem constitute a chief obstacle to any prospect of settlement and peace in the area. In its advisory opinion of 2004 on the legality of the construction of a wall, this court stated that the Israeli settlements in the occupied Palestinian territory, including East Jerusalem, have been established in breach of international law. The Security Council has in numerous resolutions, including 2334 of 2016, restated its determination that the settlements constitute a flagrant violation of international law, and stressed the need to reverse the negative trends on the ground which are steadily eroding the two-state solution and entrenching a one-state reality. Against this background, I will first address administration and annexation of territory under occupation. I will then ask whether Israel's continued occupation may still be seen as temporary administration of territory in accordance with international law on military occupation, or whether the occupied Palestinian territory is gradually being subject to illegal annexation. Drawing on the court's advisory opinion in Namibia, I will pose the question whether Israel must end its occupation of the territory. Ambassador FIFA will thereafter address specific elements which are part of the legal framework applicable under international law to the occupied Palestinian territory. At the outset, we recall that the definition of occupied territory in Article 42 of the 1907 Hague Regulations relies on a factual assessment. A territory is considered occupied when it is actually placed under the authority of the hostile army. This triggers key legal rules, in particular out of humanitarian considerations and notably pursuant to the Fourth Geneva Convention. The factual assessment made by this court at the time of the Wall opinion remains, in our view, entirely true today. Both the Gaza Strip and the West Bank are integral parts of the territory occupied by Israel in 1967, irrespective of the Israel military withdrawal from Gaza in 2005. The Security Council recently stressed in its resolution 2720 of 2023 that the Gaza Strip constitutes an integral part of the territory occupied in 1967, and reiterated the vision of the two-state solution with the Gaza Strip as part of the Palestinian state, echoing its resolution 1860 of 2009. The protection given to the civilian population by the laws of occupation continue to apply. This does, however, not impede a consideration of the legality of the occupation as such. The occupation has now lasted for more than half a century. While international law does not set any specific time limit, military occupation is, in essence, temporary. This is evident from provisions such as Articles 6.3 and 47 of the Fourth Geneva Convention, and was recalled by the General Assembly in its Resolution 77/126 in 2022, emphasizing that the occupation of a territory is to be a temporary de facto situation, whereby the occupying power can neither claim possession nor exert its sovereignty over the territory it occupies. Recognized authorities have reminded us that the law on belligerent occupation is based on the assumption that occupation of foreign territory, being an extraordinary measure, may be justified for a limited time only. A military occupation cannot be permanent. If an occupation is allowed to be indefinite, then the distinction under jus ad bellum between occupation and annexation dissolves. Furthermore, risks are patent with regard to deportations, transfers and evacuations in breach of Article 49 of the Fourth Geneva Convention. Both this court and the Security Council have found Israel to have violated this provision. Such developments give reason to ask whether the situation is turning into a de facto annexation. I now turn to the possible legal consequences arising from such prolonged occupation with regard to the Palestinian people's right to self-determination. In its advisory opinion on the Wall, the court noted that the principle of self-determination of peoples has been enshrined in the United Nations Charter and reaffirmed by the General Assembly in Resolution 2625. Pursuant to which every state has the duty to refrain from any forcible action which deprives peoples referred to of their right to self-determination. The court notes in para 149 that Israel is bound to comply with its obligation to respect the rights of the Palestinian people to self-determination. It added that there was a risk of further alterations to the demographic composition of the territory, contributing to the departure of Palestinian population from certain areas. On this basis, the court concluded that the construction of the wall, along with the measures taken previously, severely impeded the exercise by the Palestinian people to its right to self-determination and is therefore a breach of Israel's obligations to respect that right. In its 2019 advisory opinion on Chagos, para 160, The court emphasized the customary law character of the right to territorial integrity of a non-self-governing territory as a corollary of the right to self-determination. It follows that any detachment by the administering power of part of a non-self-governing territory, unless based on the freely expressed and genuine will of the people of that territory, is contrary to the right to self-determination. Norway believes that permanent or irreversible measures taken by Israel on occupied Palestinian territory would likewise be contrary to the Palestinian people's right to self-determination. I turn now to annexation. Annexation is a unilateral act by which a state incorporates into its territory all or part of the territory of another. As a concomitant of the prohibition on the threat or use of force in Article 2.4 of the UN Charter, annexation is prohibited under customary international law. This prohibition is reflected in Security Council Resolution 242 of 1967, referring to the inadmissibility of the acquisition of territory by war, repeated in its Resolution 298 of 1971. It is on this basis that the Security Council, in its Resolution 469 of 1980, declared Israel's de jure annexation of East Jerusalem to be invalid. What form annexation takes is irrelevant. To quote the court, with regard to the question of form, it should be observed that this is not a domain in which international law imposes any special or strict requirements. This is why it must be reiterated that annexation under any form, whether de jure or de facto, is illegal under international law. The formal characterization is immaterial. Nevertheless, there are grounds for asking whether Israel's occupation may be seen as tantamount to de facto annexation, as the court did in the Wall opinion. And I quote, "The construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent, in which case, and notwithstanding the formal characterization of the wall by Israel, it would be tantamount to de facto annexation." End of quote. In its September 2022 report, the Independent International Commission of Inquiry on the occupied Palestinian territory, including East Jerusalem, held that, quote, "Israel treats the occupation as permanent and has, for all intents and purposes, annexed parts of the West Bank, while seeking to hide behind a fiction of temporariness. Actions by Israel constituting de facto annexation include expropriating land and natural resources, establishing settlements and outposts, maintaining a restrictive and discriminatory planning and building regime for Palestinians, and extending Israeli law extraterritorially to Israeli settlers in the West Bank." The Commission considered the situation tantamount to a de facto annexation as alluded to by the court. The court may wish to consider the following aspects when determining whether Israel's occupation may be tantamount to de facto annexation. First, the establishment of settlements in the occupied Palestinian territory represents a transfer over decades of parts of the occupying power's own civilian population into the territory it occupies in breach of Article 49.6 of the Fourth Geneva Convention. The Security Council has repeatedly, including in Resolution 2334 of 2016, condemned all measures aimed at altering the demographic composition, character and status of the territory occupied since 1967. Second, it could be asked whether the duration of the occupation, which has now lasted for more than half a century, in itself renders the occupation tantamount to de facto annexation. Third, there are grounds for serious concerns regarding announced plans for further expansion of Israeli settlements in the West Bank, including East Jerusalem. Fourth, Israel has appropriated natural resources of the West Bank, including water resources, and seized control of a physical infrastructure in order to bind the area closer to itself, and, it seems, to render irreversible its presence in the territory. Of particular concern are the repeated demolitions of the local Palestinian Bedouin communities and plans for infrastructure constructions that will isolate Bethlehem and the southern West Bank from East Jerusalem. Fifth, political leaders in Israel have stated that Israel's aim is a de facto annexation of the territory. In 2019, Prime Minister Benjamin Netanyahu declared that Israel would continue to build and develop the West Bank. He said that not one resident or community will be uprooted in a political agreement, and Israeli military and security forces will continue to rule the entire territory. He later pledged that his government would be applying Israeli sovereignty over all the communities to which Israeli settlers had been transferred. Norway looks forward to the determination by the court whether the occupation may have become tantamount to de facto annexation. Moreover, statements legitimizing extension of settlements may constitute direct and public incitements to commit further serious violations of international law. The State of Israel must take all measures within its power to prevent and punish such incitements. Norway believes that it would be useful to clearly set out the illegality of any measures tantamount to de facto annexation and underline the clear, continued legal obligation of the occupying power as regards protected persons in the territory occupied since 1967. In the case that the court reaches the conclusion that the situation in the occupied Palestinian territories must be seen as tantamount to de facto annexation, the next question is, what would be the legal consequences for Israel? In the 1971 Namibia opinion, this court referred to an obligation on the part of the occupant to withdraw its administration of the territory immediately or as rapidly as possible. Analogous conclusions were drawn by the court in the Chagos opinion. Furthermore, the Security Council, in Resolution 476 of 1980, reaffirmed the overriding necessity for ending the prolonged occupation. Mr. President, in the Namibia opinion, the court was mindful of the fundamental consideration that it should not make any determination that would result in adversely affecting the population of the territory in question. This principle is codified in Article 47 of the Fourth Geneva Convention as a cardinal safeguard. The provision clearly expresses the general principle that the Fourth Geneva Convention protects civilians regardless of the status of the territory in question. Moreover, the formal characterization of the occupied territory cannot relieve the occupying power of the obligation it owes to the population of that territory. Clear legal obligations incumbent on Israel include access of humanitarian actors to the occupied Palestinian territory, including the Gaza Strip. In Resolution 2720 of 2023, the Security Council reiterated its demand that all parties to the conflict, including Israel, comply with their obligations, including with regard to humanitarian access and the protection of humanitarian personnel and their freedom of movement. I thank you for your attention. I will now ask Ambassador Rolf Einar Fife to come to the podium.
I thank Mr. Jarvel. I now give the floor to Mr. Fife. You have the floor, sir.
Mr. President, distinguished members of the Court, it is an honor for me to appear again before this Court on behalf of the Kingdom of Norway. For completeness, I will now address certain elements which Norway considers to be part of the legal framework applicable to the occupied Palestinian territory. They constitute, in our view, solid foundations under international law for the two-state solution to which Norway is fully committed. Mr. President, I would like to start by noting the statement before this court on the 12th of January by the co-agent of Israel in a contentious case when he recalled, and I quote, "the commitments made at the time the state was established as reflected in our Declaration of Independence," end of quote. This reminder of the commitments made in the Declaration of Independence of the State of Israel on the 14th of May 1948 is indeed important. The Declaration is a key constitutive document for the establishment of the State of Israel. It is based on the strength of Resolution 181 of 1947 of the UN General Assembly concerning the plan of partition with economic union. It is indeed rare to find similar constitutional documents that are explicitly based on a specific United Nations resolution, as was done here. The Declaration added that the State of Israel was, and I quote, "prepared to cooperate with the agencies and representatives of the United Nations in implementing the resolution," end of quote. Furthermore, the resolution was considered in the Declaration to constitute an irrevocable recognition by the United Nations of the right to establish a state. This ought to imply that the same applies to the Palestinian side. An international legal framework has since been built, in a figurative sense, brick by brick, under the auspices of the United Nations, with a view to achieving a two-state solution. And a point of departure here are the commitments made at the time the State of Israel was established, and their subsequent legal relevance. On the 15th of May 1948, the Foreign Minister of the Provisional Government of Israel, Mr. Moshe Sharet, transmitted the contents of the Declaration of Independence to the Secretary General of the UN, Mr. Trygve Lie. On the day independence was declared, Arab neighboring states attacked Israel. On the 16th of November that year, the Security Council demanded in Resolution 62 the establishment of an armistice in all sectors of Palestine. The armistice demarcation lines, later established and since referred to as the Green Line, were without prejudice to future territorial settlements or boundary lines. On the 29th of November that same year, Foreign Minister Sharet sent a formal application for membership in the United Nations to the Secretary General. The letter stated that independence had been proclaimed, and I quote, "in pursuance of Resolution 181 of the General Assembly." It added that Israel unreservedly accepts the obligations of the United Nations Charter and undertakes to honor them from the day when it becomes a member of the United Nations, end of quote. Mr. President, the subsequent decision-making process concerning UN membership in accordance with Article 4 of the Charter is significant. Pursuant to Article 22 of the Covenant for the League of Nations and the adoption of Class A mandate, Palestine had been provisionally recognized in 1922 as an independent nation, subject to the rendering of administrative advice and assistance by a mandatory, until such time as it was able to stand alone. By virtue of Article 80 of the Charter, rights of self-determination were not altered in 1945. They were continued. The announced notice of termination of the Palestine Mandate by the United Kingdom in 1947 provided the background for the adoption of Resolution 181, already referred to. Norway voted in favor of that resolution. The two-state solution formed the context of the vote on admission of Israel to UN membership. On the 4th of March 1949, as a member of the Security Council, Norway voted in favor of such admission, stating in its explanation of vote that it was, and I quote, confident that Israel will cooperate fully and loyally with all decisions by organs of the United Nations, end of quote. Subsequently, on the 11th of May that same year, Norway also voted in favor of Resolution 273 on admission in the General Assembly. This decisive resolution referred to Resolution 181 of 1947, but also to, and I quote, the declarations and explanations made by the representatives of the government of Israel before the ad hoc political committee in respect to the implementation of the said resolutions, end of quote. Indeed, from the 5th to the 9th of May 1949, Israel's representative in that committee, Mr. Abba Eban, had fielded questions from member states. His assurances became an integral part of assessments made by the relevant UN organs as regards membership. For instance, on the 5th of May, Mr. Eban recalled that Resolution 181 recommended that when either state envisaged by that resolution had made its independence effective, end of quote, sympathetic consideration should be given to membership in the UN. He added that, and I quote, the time had come for the UN, if it wished Israel to bear the heavy burden of charter obligations, to confer upon Israel the protection and status of the charter, end of quote. After the decisive vote in the General Assembly, Foreign Minister Sharet stated that the aftermath of the war had changed some elements in the pattern envisaged in the 1947 resolution, and that modifications were therefore called for. However, these do not vacate the continued relevance of the framework. The Foreign Minister noted that Israel's organic connection with the United Nations had combined with its own compelling interest in dictating its course of action in international affairs, a cause of undivided loyalty to the Charter of the United Nations and of consecration of the cause of peace, end of quote. Mr. President, such declarations, such explanations were instrumental in securing a majority of votes in the relevant organs of the United Nations. To a Norwegian, they may moreover invite a recollection of the so-called Eland Declaration. Assurances given by a foreign minister may, under certain circumstances, give rise to legal consequences as unilateral acts. After exercise of the right of self-determination had led to the establishment of the states of Jordan and Israel, the legal framework just described continues to be applicable today. Returning to the current situation, the illegality under international law of certain measures described has already been authoritatively and abundantly made clear. As an example, the unanimously adopted Security Council Resolution 465 of 1980 determined that all measures taken by Israel to change the character, composition, structure, or status of Arab-occupied territories since 1967 have no legal validity. For the sake of good order, it should be noted that nothing in the later peace process, including instruments often collectively referred to as the Oslo Accords, impairs this assessment. These instruments are based on an explicit recognition of the, I quote, legitimate rights of the Palestinian people and their just requirements, end of quote. Neither side shall, according to these instruments, initiate or take any step that will change the status of the West Bank and the Gaza Strip, pending the outcome of the permanent status negotiations. It is the view of Norway that a permanent settlement based on Security Council resolutions 242 and 338, must build on a confirmation of the role of international law and of the international legal framework that we have attempted to briefly describe here. Mr. President, our observations do not imply any lack of legitimacy of the establishment or of the rights of the State of Israel. On the contrary, they build on it. However, they also recall the clear obligations of a legal and not merely of a political nature incumbent on Israel. These rights and obligations correlate. They require fully contributing to the realization of a viable state of Palestine. The permanent and irreversible nature of measures described under the prolonged occupation with illegal settlements conducted in relation to the Gaza Strip run counter to the Charter and also to the very commitments made by Israel. It is against this background, Mr. President, members of the Court, that we invite the Court to pronounce itself on the legality of the measures described and of the continued occupation. I've come to the end of my presentation and I thank you for your attention.
I thank the delegation of Norway for its presentation. I call upon the next participating delegation, Oman, to address the Court and invite His Excellency Mr. Abdullah bin Salim bin Hamad al-Harithi to take the floor.
Mr. President, distinguished honorable members of the Court, it is an honor and privilege to appear in front of the Court to present a statement on behalf of the government of the Sultanate of Oman in the oral proceedings concerning the advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. For more than 75 years, the Palestinians have been living under occupation, oppression, injustice, and daily humiliation committed against them by Israelis. Meanwhile, the international community and the international organizations have failed to assist the people of Palestine to realize their aspiration by having their own independent state. Today in Gaza, the world for 4 months is witnessing one of the worst atrocities and acts of genocide in modern times, where more than 25,000 killed and 69,000 wounded, in addition to 2.2 million living under unbearable conditions, being driven from one place to another in a clear violation of international norms. The advisory opinion request. Oman supports United Nations United Nations Resolution 77/247 of 30 December 2022, in which the Assembly requested the Court to render an advisory opinion in relation to 2 specific issues, namely, A, the legal consequences arising from Israel's ongoing violation of the right of the Palestinian people to self-determination. Its prolonged occupation of the Palestinian territory occupied since 1967, including the holy city of Jerusalem, and its measures aimed at altering the demographic composition, character, and status of the Palestinian territories, and from its adoption for related discriminatory legislations and measures. B. Israel's policies and practices referred in paragraph A affect the legal status of the occupation and the legal consequences that arise for all states and the United Nations from this status. The Sultanate of Oman requests that the following issues are taken in account. 1. Violation of the right to self-determination. That the occupation, settlement, and annexation of Palestinian territory occupied since 1967 by Israel obstructs the realization of the Palestinian people's inalienable rights, including their right to self-determination and right to return. There is an overwhelming international agreement on the existence of the right to self-determination and its continued denial in the occupied Palestinian territories. The right to self-determination is enshrined inter alia in Article 1(2) of the Charter of the United Nations. The United Nations General Assembly has consistently reaffirmed the right of the Palestinian people to self-determination. The United Nations Security Council has called for an end to the Israeli occupation and the establishment of two states based on the 1967 line. The Human Rights Council consistently recognizes the inalienable, permanent, and qualified right to self-determination of the Palestinian people. Arising from these clear and consistent breaches of the international law in maintaining a 75-year occupation, the court should determine that the government of Israel should bring an immediate and unconditional end to all activities, policies, and laws that prevent and impede Palestinian self-determination, principally by ending the occupation of the Palestinian territory. The court should recognize the clear responsibility on all states to support the establishment of Palestinian self-determination in the line with United Nations resolutions and the United Nations Charter. 2. Prolonged occupation, settlement, and annexation of Palestinian territory. The consistent and systematic and lawful transfer of Israeli citizens to settlements in occupied Palestinian territory over decades is designed to perpetuate the occupation and make it permanent. Related to this policy is the displacement of Palestinians and establishment of coercive system of discrimination, zoning, planning, unlawful land appropriation, arbitrary arrest, and arbitrary violence since 1967. This foreseeable displacement of the occupied people and the transfer of citizens of the occupying power to occupied territory is prohibited under Article 49 of the Fourth Geneva Convention on the Protection of Civilian Persons in Time of War. Article 1 of that convention stipulates that every high contracting party to the convention is under an obligation to ensure compliance in all circumstances. The United Nations General Assembly, United Nations Security Council, and United Nations Human Rights Council have consistently and repeatedly condemned Israel's effort to alter the demographic character and status of the occupied Palestinian territories. States' obligations. The international community has an obligation to prevent unlawful annexation of Palestinian land. A fundamental principle of international law, as reflected in the Charter of the United Nations, is that the use of force in any form is prohibited. Consequently, accusation of territory by use of force is illegal. The 75-year occupation and settlement policy of State of Israel is preventing the establishment of contiguous, viable Palestinian state is an affront to international law. The court should find that the legal consequences for the government of Israel in this regard should include the immediate cessation of all illegal acts, including settlements and associated legal and administrative frameworks, clearly reparations for and dismantling of illegal structures and legal frameworks is also an imperative. Third states are under a clear obligation not to recognize or assist the illegal situation present in the occupied Palestinian territory. State parties to the Geneva Convention relative to the protection of civilian persons in time of war and under obligation to ensure Israeli compliance with international humanitarian law as embodied in the Convention, including the unlawful transfer of citizens to occupied territories. United Nations General Assembly Resolution 77/25 called upon all states consistent with their obligations under the Charter and relevant Security Council resolutions to pursue a policy of non-recognition, non-cooperation, non-assistance to the Israeli occupation, and to ensure respect for international law in this regard. I would like to conclude that the primary legal consequences arising from Israel's behavior is that there is now a de facto annexation by Israel of the Palestinian territories. There is no legal justification for continuing the Israelis' occupation and denying the Palestinian people right to self-determination. The Sultanate of Oman requests that the following issues are to be taken into account. A. The conduct and practices of an occupying power are well documented and strictly regulated in international law. The Fourth Geneva Convention is clear that an occupying power may not transfer its civilian population to occupied territories. In addition, international law does not provide for permanent occupation or occupation legitimized through the establishment of demographic change through settlement. The 75-year duration of Israeli presence in the occupied Palestinian territories and the persistence policy of settlement renders the Israeli occupation illegal and in breach of the United Nations Charter. B. The court should determine that Israel should bring to an immediate and unconditional end to this unlawful situation. Third states should support these efforts. Thank you very much.
I thank the delegation of Oman for its presentation, and before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. This sitting is suspended. Please be seated. The sitting is resumed. I now call upon the delegation of Pakistan to address the court and invite His Excellency Mr. Ahmad Irfan Aslam to take the floor.
Mr. President, members of the court, it is an honor to appear before you on behalf of Islamic Republic of Pakistan in these most important of proceedings. These proceedings take place as a whole people struggle to survive through relentless bombardment. The very people who have endured daily persecution for over half a century. And yet, these proceedings inspire hope. They inspire hope because they present an opportunity. They afford this court an opportunity to develop jurisprudence, to advance essential principles of international law that preserves and advances the very basic human right of liberty and dignity. Pakistan has always been a defender of the Palestinian people and their right to self-determination. It was Pakistan that proposed the General Assembly's first resolution on the first day of the Six-Day War relating to Israel's invasion of Jerusalem and the measures taken by Israel to change the status of the city. Since then, Pakistan has continued to engage on these important questions of international justice, and it remains committed to contribute and play its part. Against this background, I will deal initially with 5 points and then make some technical legal arguments that Pakistan considers to be of particular importance in these proceedings. First, the question of self-determination. Second, the question of occupation and annexation. Third, systematic racial discrimination and apartheid. Fourth, the question of City of Jerusalem and its holy places. And finally, the two-state solution. Mr. President, members of the court, I come to my first point. The Palestinian people have, as the court itself has recognized, the right to self-determination. This right, which is codified in the two United Nations Human Rights Conventions, is one of the essential principles of contemporary international law. All states have a legal interest in protecting that right, which has the status of jus cogens. Israeli measures that severely impede the exercise by the Palestinian people of the right to self-determination are in breach of Israel's obligations to respect that right. Pakistan strongly believes in the inherent right of people to live freely and in the justice of struggle for freedom from alien subjugation under the right of self-determination. I turn to my second point, the question of Israel's occupation and annexation. It has always been the position of the United Nations that it, and I quote, cannot condone a change in the status juris resulting from military action contrary to the provisions of the Charter. The organization must therefore maintain that the status juris existing prior to such military action to be re-established by a withdrawal of troops and by the relinquishment or nullification of rights asserted in territories covered by the military action." End of quote. Thus, after the Six-Day War, the Security Council determined in Resolution 242 of 1967 that Israel must withdraw its armed forces from territories occupied in the recent conflict. In Resolution 476 of 1980, the Security Council reaffirmed the overriding necessity for ending the oppression of Arab territories occupied by Israel since 1967. Israel's occupation is no longer, if it ever was, a military occupation. It is annexation. In East Jerusalem, the annexation is de jure. In the rest of the territory, it is de facto. But the formal characterization matters little. To use the words of the court in the Wall case, the occupation is today, and I quote, "notwithstanding the formal characterization, tantamount to de facto annexation," end of quote. This now applies to the entire territory. This may have been the intention all along. Prime Minister Ben-Gurion affirmed in 1950 that, and I quote, "the Israeli empire must comprise all the territories between the Nile and the Euphrates," end of quote. And this was to be achieved as much by invasion as by diplomacy. More recently, Prime Minister Netanyahu has declared that his government will be, and I quote, "applying Israeli sovereignty over all the communities formed through the transfer of Israeli settlers, and not one resident or community will be uprooted," end of quote. Through its settlement policy, Israel has sought to create irreversible facts on the ground. It has aimed to create physical facts, which in practical terms make it as difficult as possible to bring an end to its prolonged occupation, the West Bank and East Jerusalem. Notwithstanding, the Security Council has reaffirmed that the settlements constitute, and I quote, "a flagrant violation under international law," end of quote. As this court said in the Namibia case, a binding determination made by a competent organ of the United Nations to the effect that a situation is illegal cannot remain without consequence. As in that case, in answering the legal questions now referred to it, the court is not concerned with the question of what practical steps would be required to seize the occupation. It is worth recalling, however, that even greater practical issues have been overcome in other contexts, such as when the French government withdrew 1 million settlers from Algeria in 1962. The French settlers were more numerous than the Israeli settlers in the West Bank and East Jerusalem taken together. France's settlements in Algeria were not only more numerous, they were also far older and better established than Israel's West Bank colonies. I come to my third point regarding systematic racial discrimination. Israel's policies and practices amount to systematic racial discrimination and apartheid. Israel has imposed a system of racial discrimination against the Palestinian people since 1967. It is a system that distinguishes deliberately and systematically along ethnic and religious lines between the Palestinian population and Jewish Israeli settlers illegally transferred into the territory. The purpose of domination and oppression may be inferred from Israel's pattern of conduct against the Palestinians. I turn to my fourth point, Jerusalem and its holy places. The holy city of Jerusalem is unique in that it is sacred to all three Abrahamic religions. Under the historic status quo, it is the right of Christian, Jewish and Muslim communities freely to access and worship at their holy places in the city. Ottoman decrees set out these rights in the 19th century. The regime was later confirmed in multilateral and bilateral instruments. The historic status quo has today developed into a so-called objective regime, which captures the point that it is characterized by a permanence which the instruments that established it do not themselves necessarily enjoy. Every state interested, therefore, has the right to insist upon compliance with this regime. Under Israel's prolonged occupation, Christians have not been free to access or worship in the Church of the Holy Sepulchre, and Muslims have not been free to access or worship at Haram al-Sharif and in the Al-Aqsa Mosque, to name only some prominent sites. The rights under the historic status quo must immediately be restored. This issue is of great importance to Pakistan, which is home to the second largest Muslim population in the world. And now I come to my final point of the first part of my statement. Pakistan believes that the two-state solution must be the basis for peace. In the Wall case, this court observed that the two-state solution was to be encouraged, and I quote, with a view to achieving as soon as possible, on the basis of international law, a negotiated solution to the outstanding problems and the establishment of a Palestinian state existing side by side with Israel and its other neighbors, with peace and security for all in the region. End of quote. Pakistan supports this call. On 26th of October 2023, Pakistan was pleased to vote in favor of General Assembly resolution which reaffirmed that, and I quote, a just and lasting solution to the Israeli-Palestinian conflict can only be achieved in accordance with international law and on the basis of the two-state solution. 2 months later, on 22nd of December 2023, the Security Council reiterated its unwavering commitment to the vision of the two states, consistent with international law and relevant UN resolutions. And these and numerous other resolutions by the political organs of the United Nations make clear a two-state solution and negotiations leading to it must be consistent with international law. Negotiations, Judge Onal Khassani of this court observed in the Wall case, and I quote, are a means to an end and cannot in themselves replace that end, end of quote. He continued to say that the discharge of fundamental international obligations cannot be made conditional upon negotiations. In this regard, the court's advisory opinion in these proceedings will be most important. Far from impeding negotiations in the achievement of a just and lasting two states, the court's advisory opinion will further assist such efforts by making it possible for the parties to make progress on the sound basis of international law and international legitimacy. Mr. President, members of the court, I now turn to more technical legal arguments of my submissions. The court has heard various competing submissions this week with respect to question B of the request. But there can be little doubt as to the central importance of three matters. First, the role of the rules on the use of force in governing the unlawfulness of a given occupation itself. Second, the series of General Assembly and Security Council resolutions that have consistently and expressly called for Israel's withdrawal and referred to the inadmissibility of the acquisition of territory by war, which is a corollary of those rules. Third, the Court's advisory opinion on Namibia is a helpful reference point for the Court. Pakistan hopes to assist the Court by suggesting a slightly different way of looking at things, which leads to the conclusion that Israel's occupation is unlawful and unlawfulness must have consequences. In this respect, Pakistan considers that a useful touchstone for the Court is the general principle that no state can benefit from its own wrong. As Sir Gerald Fitzmaurice explained, and I quote, "The general principle is that states cannot profit from their own wrong, and similarly that rights and benefits cannot be derived from wrongdoing. This admits of no doubt. It is a wide general principle having many diverse applications under international law. Of course, these principles apply not merely as regards treaty obligations, but to general international law obligations also." End of quote. Notably, in the Wall case, Israel accepted that this principle is as relevant in advisory opinions as it is in contentious cases. The principle is particularly important, whereas here the wrongs at issue are of the most serious kind. Second, the principle in the context of applicable law. This principle is one of the underpinnings of the prohibition on the acquisition of territory either by force or through the denial of self-determination. The wrongs are obvious, and no benefit in terms of lawful possession or a legal entitlement to administer the territory could be derived. As to this case, if the Court agrees with Pakistan and with many other states that Israel is in continued breach of these fundamental primary obligations, it cannot allow Israel to benefit from its own ongoing wrongs by somehow avoiding the natural consequences that must follow under this law of state responsibility. These include the obligations of cessation and non-repetition, which require immediate and unconditional withdrawal, as well as the obligations of non-recognition and non-assistance for all other states. As to the applicable primary rules, it is customary international law and the charter that govern the illegality of a given occupation at any point in time. As a separate matter, international humanitarian law governs the conduct of an occupying power with respect to the occupied population. But if the occupation itself is unlawful, that carries legal consequences for Israel and for all states under the secondary rules of state responsibility. Those legal consequences are in no way displaced by separate consideration of the lawfulness under international humanitarian law of particular conduct in the course of the occupation, much less by hope for a negotiated solution. Any other approach would effectively permit Israel to benefit from its own wrongdoing. For the same reason, there is no scope for an argument that other states in their dealings with respect to Israel or the occupied Palestinian territory could somehow put to one side the question of the unlawfulness of the occupation itself. They could not, for example, elect instead to focus exclusively on the different questions of whether specific Israeli measures were absolutely necessary to meet legitimate security requirements, such that those measures are not unlawful under international humanitarian law. Third, the principle in the context of Namibia advisory opinion. Mr. President, members of the Court, any conclusion could not be reconciled with the Court's opinion on Namibia. There are certain clear parallels with the present case. The General Assembly had condemned South Africa's occupation of Namibia, characterizing this as an occupation that engaged the Geneva Conventions, and the Security Council had expressly called for South Africa's withdrawal. In a later resolution, after condemning South Africa's non-compliance with the earlier resolutions, the Security Council had also declared that, and I quote, "the continued presence of South African authorities in Namibia is illegal," end of quote. This is to be understood as a reference to illegality under the rules on the use of force. Notably, the United States voted in favor of this resolution. With respect to Palestine, however, it now appears to wish to limit those rules to governing the lawfulness of the initial resort to force leading to occupation only. Of course, that could not be correct, including because it would allow an aggressor to benefit from an ongoing attempt to acquire territory through annexation. Indeed, in its 1971 advisory opinion, the court itself concluded the continued presence of South Africa in Namibia is illegal. The court held that South Africa was under an obligation to withdraw immediately and that all states were under an obligation to recognize the illegality of the occupation. In reaching this conclusion, the court found that South Africa's application of the apartheid regime to occupied territories amounted to disowning the mandate. In connection, the court relied on a context-specific expression of the general principle that no state can benefit from its own wrong, stating, and I quote, "One of the fundamental principles governing international relationship thus established is that a party which disowns or does not fulfill its own obligations cannot be recognized as retaining the rights which it claims to derive from the relationships," end of quote. South Africa had claimed it had an independent right to administer the territory by reason of its long occupation. Evidently, the court disagreed. 3 points follow from this. First, the court in Namibia case implicitly recognized that neither the fact of an occupation nor the law of occupation confer upon the occupying power any legal entitlement to administer the territory. Any contrary view would allow an occupying power to benefit from its unlawful use of force. Second, the court made a positive finding that South Africa's occupation was unlawful. In Namibia, there was a binding Security Council decision to that effect. The Security Council has made no such Security Council decision with respect to Palestine. But this in no way displaces or impedes the court's judicial function in determining this legal question for itself. Third, the court plainly did not consider that South Africa's continued status as an occupying power made any difference. As Judge Greenwood has explained, the basic position under the law of occupation is that an occupying power has the liberty to govern within certain limits without being guilty of violation of the jus in bello. The occupying power is required to administer the territory as temporary conservator or trustee for the benefit of the occupied population. Acting in that capacity, the occupying power has certain liberties to take measures in good faith, in the best interest of the occupied population, or where absolutely necessary to meet its own legitimate security interests. This, of course, is a separate question to the unlawfulness of the occupation itself. As to the position under the law of occupation, again, it is helpful to recall the Namibia case. The court's context-specific expression of the principle was that, and I quote, "a party which disowns or does not fulfill its own obligations cannot be recognized as retaining the right which it claims to derive from the relationship," end of quote. Pakistan considers that this has relevance when considering whether an occupying power should be recognized as retaining liberties to administer the occupied territory. In this case, if one were to zoom in exclusively on Israel's conduct as an occupying power, the only conclusion could be that Israel has disowned its basic duties. Its policies and practices of occupation deny the rights of the Palestinian people to self-determination and amount to systematic racial discrimination and serious violations of international humanitarian law and human rights. Plainly, they cannot be said to be absolutely necessary to meet Israel's own security interests. They serve Israel's other interests, including its goal of acquiring the territory. Mr. President, members of the Court, I conclude with the general principle that no state can benefit from its own wrong. Firmly in mind, it cannot be right that, as some states have suggested, the Court should refrain from finding that the occupation itself is unlawful or that there is no obligation to withdraw. This would be to allow Israel to profit from its own continued grave wrongs. And to adopt the Court's words in Namibia, the Court would be failing in the discharge of its judicial functions. Such abdication of responsibility would not encourage or facilitate the achievement of a negotiated solution on the basis of international law. More generally, the Court would be sending out a clear signal to other states that they too might be allowed to benefit the prolonged and lawful occupation of the territory of another state. Mr. President, members of the Court, these proceedings are a great moment in law. They are a great moment in history. We all have a collective opportunity to develop jurisprudence in a way that advances the cause of humanity. I wish you good luck in your deliberations. Thank you.
I thank the delegation of Pakistan for its presentation. I invite the next participating delegation, Indonesia, to address the Court, and I call Her Excellency Ms. Retno Marsudi to the podium.
Bismillahirrahmanirrahim. Mr. President, distinguished members of the Court, I left my G20 meeting in Rio de Janeiro to stand before you today on behalf of the government of the Republic of Indonesia to express the solidarity of the Indonesian people on a matter of supreme and grave importance, a matter that strikes at our fragile humanity. I stand before you today to defend justice against the blatant violation of international law that has been committed by Israel. We have all witnessed the ongoing humanitarian catastrophe in Gaza and the following escalation throughout the region, which have emboldened a global call to address the root cause, the illegal Israeli occupation on Palestine. Israel's unlawful occupation and its atrocities must stop, and neither should it be normalized nor recognized. Mr. President, members of the Court, it is clear that Israel has zero intention to respect, let alone abide by, its international legal obligation. The Prime Minister Benjamin Netanyahu even said, and I quote, "Nobody will stop us, not The Hague, not anybody else," unquote. This is also evident in Israel's action in Gaza, as it is continuing its indiscriminative campaign of annihilation against civilians in Gaza. Apparently, the death of almost 30,000 lives is not enough for Israel, as it is close to launch another strike on Rafah, once the only gateway for life-saving humanitarian assistance to Gaza. No state should be granted a free rein to do anything they want against weaker state. This is why we have international law. This is why we need to uphold it. The role of ICJ is central to safeguard what the so-called rule-based international order. There is a big hope from the international community. I repeat, a big hope that ICJ delivers a favorable advisory opinion to the interests of justice and humanity. Mr. President, members of the court, the hope is on this court. Against this backdrop, we all assume a collective moral duty to furnish information on the question submitted to the court. Mr. President, members of the court, my statement today will be divided into two parts. First, on jurisdiction, and second, on the merit of the case. First part, on jurisdiction. Indonesia maintains that the court has jurisdiction to render the advisory opinion, and there is no ground for declining to exercise such jurisdiction. This has been clearly elaborated in Indonesia's written statement and written comment. Now I will focus on rebuffing the argument of some states, suggesting that rendering an advisory opinion would somehow undermine the peace process. While the court has made their opinion clear on this matter, allow me to further stress three arguments. First, there is no viable peace process to be undermined. Israel has been consistently obstructing a negotiated two-state solution. This is in line with international law and relevant United Nations resolution. Israel has even been circumventing negotiation through numerous strategic pretexts. With such strong resistance from Israel to stop its colonial project and its fait accompli unilateral action, no peace process will validly bring a just, lasting, and comprehensive solution. After all, negotiation with someone holding a gun against your head is not a negotiation at all. Despite this rhetoric on peace, successive government of Israel has openly expressed their abandonment of the peace process, including by declaring the Oslo Accord null and void. Just last November, Prime Minister Netanyahu even boasted that, and I quote, "I'm proud that I prevented the establishment of Palestinian state," unquote. It is no wonder that Israeli officials of all levels have been openly ignoring the calls from the UN Security Council to settle this issue peacefully and abide by its international obligation. Along with these attitudes, Israel only has been pursuing a one-sided solution without engaging Palestinians, let alone addressing their interests. Indonesia submits that this confirming Israel has never been interested in any peace process. Second, the request for advisory opinion is not intended to decide on a final solution to the conflict. A comprehensive, just, and lasting solution should only be achieved through direct negotiation between the parties to the conflict, not one imposed from outside or by one party. Rather, the request is intended to seek the court opinion on legal questions asked by the UN General Assembly within its competence. The court should only render its opinion on the legal consequences arising from the ongoing violation by Israel and how they should affect the legal status of the occupation. The questions should be understood as a request for advice to facilitate the General Assembly in devising necessary action within its function. Third, the court opinion will positively contribute to the peace process by presenting additional elements of the law for a comprehensive resolution of the dispute. A genuine and lasting peace process can only be achieved if it is consistent with the international law. Thus, the court opinion is very much needed. By clarifying the relevant legal rules, the court opinion will help in resolving the stalemate that have impeded the peace process. In addition to this positive impact, the court's opinion would be useful to guide the future step to be taken by the United Nations and all states. Thus, Indonesia submits that there are no grounds to dismiss this request on the basis that it will risk fundamentally delegitimizing any future prospect of peace process. Mr. President, members of the court, my second part is on the merit of the case. Indonesia has made clear its legal argument on the question posed to the court as appeared in our written statement. I will begin with the continued denial of inalienable right of Palestinians to self-determination. In its 2004 advisory opinion on the wall, the court reasserted the Palestinian right to self-determination is no longer an issue. This confirmed the long-held belief of the international community, including as expressed through various UN Security Council and General Assembly resolutions, that the Palestinian people are entitled to self-determination. Let me reconfirm Indonesia's position in line with the court view that the fulfillment of such right is an erga omnes obligation. In other words, all countries, I repeat, all countries have a legal obligation to respect that right and to contribute to its realization. Consequently, any endorsement or recognition of Israel's policies or practices that obstruct the right to self-determination of the Palestinians shall be unlawful. Mr. President, members of the court, in addressing the issue of the right to self-determination to Palestinians, it is also important to remind ourselves that the occupation has become an instrument to suppress such a fundamental right. This court, in its opinion on the wall, as well as the UN Security Council and General Assembly in their resolution, have reaffirmed from time to time the status of Israel as an occupying power. The occupation has been prolonged and enabled by Israel's series of breaches of its obligation under international law, including international humanitarian law and international human rights law. Now allow me to elaborate the following. First, the Israeli occupation is a result of an unjustified use of force. Therefore, the occupation should be unlawful from the beginning and continues to be so. The use of force by Israel could not be justified under the guise of self-defense. It is also in breach of the principle of necessity and proportionality. It is indeed against the prohibition of aggression, a peremptory norm of international law from which no derogation is permitted. Second, the illegal annexation of the OPT. As an occupying power, Israel is legally obliged to keep its occupation temporary. This has been violated by Israel as it has been attempting to make its occupation permanent and also to annex part of the occupied territory. As a matter of law, under no circumstances shall Israel be allowed to annex any part of the occupied territory. The UN Security Council, in its various resolutions, has reaffirmed the established principle that acquisition of territory by war is inadmissible. It is an absolute principle that applies even in circumstances where war has been resorted to lawfully, such as in self-defense, which is certainly not the case of Israel. Israel's transgression to international law does not stop there, as it has declared that Jerusalem is the eternal, undivided capital of Israel. Not only are these actions unlawful, they are also highly prejudicial to the prospect of a two-state solution. Third, continued expansion of illegal settlement. The policy of Israel in transferring its own population and forcibly displacing Palestinians from the occupied territory contravenes the fundamental rules of the international humanitarian law. This policy is a clear violation of the Article 49 of the Fourth Geneva Convention, to which Israel is a state party. It is worsened by Israel's pursuit to change the demographic composition of the West Bank. This policy demonstrates Israel's complete disregard of international law and also shows the intention to make the situation irreversible. Fourth, the apartheid policy against the Palestinians. As an occupying power, Israel is legally obliged to act in the best interests of the Palestinians. Instead, Israel has been reinforcing its prolonged occupation by imposing military orders on the Palestinian population which are not applied to Jewish Israeli settlers. The existence of separate legal regimes that are applied exclusively on different groups of people is a textbook apartheid policy that constitutes a grave violation of human rights, particularly crime against humanity. Having said that, it is clear that the continuation of such apartheid regime is paramount to another breach of peremptory norms of international law. Mr. President, distinguished members of the Court, I wish to elaborate on the legal consequences arising from these policies and practices by Israel. This should begin with respect to fundamental rights of the Palestinian people, particularly the right to self-determination, which has been systematically denied by Israel. The Court must pronounce that Israeli occupation is illegal as a whole. It follows that we must bring this illegal situation to an end. Israel must cease completely, unconditionally, and immediately all of its unlawful action and policies in the occupied Palestinian territory. With the continued presence of Israeli forces in the West Bank and Gaza, it is impossible to see Israeli compliance with its obligation. Thus, it is imperative that Israel must withdraw its forces. Given the illegal nature of the occupation, Israel withdrawal must neither be done with precondition nor subject to any negotiation. They must withdraw now. I repeat, they must withdraw now. Israel should also be obliged to make reparation both to the state of Palestine as well as to the Palestinian people. Mr. President, please allow me to recall a legal maxim which states that no one may enjoy legal benefits from illegal action. Therefore, Israel attempts to make its occupation permanent shall never be a valid ground to claim a legitimate title over the Palestinian territory. In line with this, all states and the United Nations must not recognize the illegal situation arising from the violation of international law by Israel. All states must not render any assistance to the maintenance of such violation. Moreover, all states and the United Nations should also ensure Israel compliance with its obligation under international law. Mr. President, members of the court, I would like to conclude by underlining that no country is above the law, that no country is above the law, and the sanctity of this court must be upheld. Indonesia believes that this legal motion is also a motion of global conscience. It should not be another item on the list, another proceeding to dismiss, another call to go unheeded, ignored blatantly by Israel. Never again means never again. We founded our current international system with the conviction that every single human being, I repeat, every single human being, without exception, is protected by law. Every single human being, without exception, is protected by law. Thus, let us all contemplate upon this question. Should the international community continue allowing Israel to manipulate the use of international law to justify its illegal action against the fundamental rights of the Palestine? For Indonesia, we shall not. And once again, the hope is on this court, as the court is the guardian of justice. I thank you very much.
I thank the delegation of Indonesia for its presentation. I invite the next participating delegation, Qatar, to address the court and call upon His Excellency Mutlaq Al-Qahtani to take the floor.
Mr. President, members of the court, it's a great honor to appear before you as the representative of the state of Qatar in these historic proceedings. Qatar believes firmly that it's only through full respect for international law that peace and justice can be achieved. Recent events have underscored that international legal order is under threat. Unprecedented violence, hatred, cruelty, risk undoing decades of progress in the field of human rights, humanitarian law, and the peaceful settlement of disputes. Indeed, there is growing perception in some quarters of the that international law applies to some, but not to others. That some people are seen as deserving of security, freedom, and self-determination, but others are not. Some children are deemed worthy of the law's protection, but others are killed in their thousands. Qatar rejects such double standards. International law must be upheld in all circumstances. It must be applied equally to all, and there must be accountability for all violations. Yet, more than 75 years, the life of the Palestinian people has been treated as an exception to the international rule of law. Mr. President, members of the court, you have the clear mandate and indeed the responsibility to remedy this unacceptable situation. The credibility of the international legal order depends on your opinion, and the stakes cannot be higher. Indeed, Israel's genocidal war on the people of Gaza has shown that the situation in Palestine is the most pressing threat to international peace and security. As Secretary General Guterres emphasized, recent events did not occur in a vacuum. Rather, they grew out of Israel's illegal 57-year occupation of the Palestinian territories. Israel has denied the Palestinian people's right to self-determination. It has ethnically cleansed and colonized Palestinians' lands. Furthermore, it has implemented an apartheid regime, that's to say, a regime of systematic racial oppression and discrimination established with the intent to maintain the domination of Jewish Israelis over Palestinians. To maintain that regime, it has killed, maimed, and imprisoned tens of thousands of men, women, and children. These are the root causes of the situation we face today. These same causes are the subject of the General Assembly's request for advisory opinion. 20 years after its historic wall opinion, the Court now has the entire question of Palestine squarely before it. The General Assembly did not mince its words when it posed two clear and complementary questions. Question A calls upon the Court to assess the legality of Israel's individual policies and practices in its occupation of the Palestinian territories, which I will refer to as the OPT. Question A further calls upon the Court to state the corresponding legal consequences of each of these policies and the practices. Question B, in turn, asks the Court to answer a simple but historic question: in light of numerous illegalities in the conduct of the occupation, has the occupation itself become illegal? If the answer to that question is yes, which is Qatar's submission, then the consequence is obvious. The occupation must be brought to an end. Mr. President, members of the Court, Qatar's intervention will cover three topics. First, I will briefly explain why the Court should give the advisory opinion requested by the General Assembly. Second, with reference to question A, I will recall Israel's main illegal policies and the practices in the OPT and explain that they are not isolated or accidental, but they are part of Israel's longest-standing settler colonial project in Palestine. Third, and finally, I will set forth Qatar's position on question B concerning the legal status of the occupation. I turn now to my first topic, propriety of the Court rendering the advisory opinion. Mr. President, I need not to repeat what you have already heard from numerous participants this week. The Court unequivocally has jurisdiction, and there is no compelling reason for it to refuse to give its opinion. In particular, the Court's opinion would not underestimate or undermine the possibility of a negotiated solution to the conflict. Qatar explained why, in its written comments, the so-called peace process is dead. To provide the Court with relevant historical context, Qatar engaged two most prominent historians of the Israeli-Palestinian conflicts alive today. one Palestinian, Professor Rashid Khalidi of Columbia University, and one Israeli, Professor Efli Shalim of Oxford University. Professor Khalidi and Shalim prepared two comprehensive reports covering a century of histories from 1917 to 2023. You can find those reports at tabs 2 and 2 of your folders. Professor Shalim's report is devoted to the history and diplomacy of the Israeli-Palestinian conflict from 1967 and to today. He explains how, during this time, Israel has consistently obstructed a negotiated solution. Rather than pursuing a genuine peace, Israel used the so-called peace as a diplomatic cover for its colonization of Palestine. In this context, it's difficult to see what harm the court's advisory opinion could possibly have on a non-existent peace process. On the contrary, the absence of a viable peace process only underscores the necessities of the court's advisory opinion and a solution based on international law. I turn now to my second topic, concerning question A and Israel's illegal policies and practices of the OBT. Mr. President, members of the court, Israel's illegal and discriminatory policies and practices are the tools of long-standing settler colonial project. As Qatar explained in its written statement, these policies are designed to promote a single goal: the permanent colonization of the OBT for the exclusive benefit of Israel and the Jewish Israeli settlers. This goal is essentially linked to Israel's oppressive and discriminatory practices in the OBT and is the root cause of the cycles of violence there. In Chapter 2 of its written statement, Qatar described in detail the 8 main categories of discriminatory policies and practices that Israel employs in furtherance of its settler colonial project. In Chapter 3 of its written statement, Qatar explained that these policies and practices entail a flagrant violation of international law, human rights law, and constitutes a crime against humanity, war crimes, genocide, and ethnic cleansing. It is Qatar's position that in order to fully respond to question A, the court should assess the legality of each of Israel's main policies and practices through these lenses. A fulsome response to question A is no less than a clear answer to question B. The court should not underestimate that the impact that finding of fact and law will have in bringing Israel's specific policies and practices to an end, to encouraging accountability, and to provide victims with a sense of justice. In the limited time I have today, I will briefly call some specific points about the 8 main categories of policies and practices carried out by Israel in the OBT. The first central features of Israel's settlers' colonial project is, of course, settlement. The establishment and development of Jewish Israeli settlements in the OBT began immediately after Israel occupied it in 1967. Israel establishes Jewish Israeli settlements on seized Palestinian land, finances and facilitates the construction of housing and infrastructures, and incentivizes Jews from around the world to settle there. By 2023, over 700,000 settlers, or approximately 11% of Jewish Israelis, were living in the OBT. The settlement activities is relentless. In a January 2024 report, which you can find at tab 3 of your folders, the Israeli human rights group Peace Now explained how the war in Gaza has been exploited as cover for an unprecedented surge in settlement activities. The same is happening in East Jerusalem, and even Gaza is now at risk. The Israeli security ministers recently stated that, quote, "Not only do I not rule out Jewish settlement in Gaza, I believe it is also an important thing," end quote. On January 28, 2024, a conference dedicated to the resettlement of Gaza was held in occupied Jerusalem, which was attended by 12 Israeli government ministers. Mr. President, members of the court, let me pause here to make a brief remark about the situation in Gaza as it relates to the advisory proceedings. The contentious proceedings instituted by South Africa against Israel under the Genocide Convention do not mean that the recent situation in Gaza should not be addressed here. Gaza is part of the OBT. It was occupied before October 7, and it is occupied today. Israel's policies and practices referred to in question A includes its policies and the practices in Gaza. The court will examine the situation in Gaza through the lens of the Genocide Convention in the case brought by South Africa. Here the court can and indeed must apply all aspects of international law to the situation in Gaza, including well before October 7. This brings me to Israel's second central policy and practice in the OBT, which is displacement. In order to establish its settlements in the OBT, Israel seizes public and private land and forcibly displaces Palestinians. It does so through home demolitions, evictions, building restrictions, and by establishing buffer or military zones. Again, the situation has only grown worse since October 7. As is well established, Israel has forcibly displaced at least 75% of the population in Gaza. This policy is promoted by Israeli leaders as a solution to their Palestinian demographic problem. Israeli Minister of Culture stated that the Palestinians, quote, can go to island or to the desert. The masters in Gaza should find a solution by themselves, end quote. While all eyes may be on Gaza, the situation in the West Bank is rapidly deteriorating. At least 13 different communities in the West Bank have faced forced displacement since October 7. That has resulted in the north-south stretch of 20 kilometers east of Ramallah being cleared of nearly all Palestinians. The third Israeli practice is fragmentation. In order to implement the demographic and physical control necessary to perpetuate the occupation and establish further settlements, Israel divides and isolates Palestinians. It relegates them to fragmented enclaves, restricts their movement, and renders their daily lives all but unlivable. This is what Namibia and Belize aptly referred as strategic fragmentation. Israel has imposed a full blockade on Gaza since 2007, entirely cutting its population off from the rest of the world. October 7, Gaza had already been described by the UN Secretary General as hell on earth. Today, it is indescribable. In the West Bank, Israel has for decades implemented a system of draconian checkpoints, subjecting millions of Palestinians to daily indignities. Human Rights Watch has documented, quote, more than 40 kilometers of West Bank roads that authorities prohibit Palestinians from traveling on, end quote. Since October 7, Israel has implemented unprecedented lockdown on the entire civilian territory of the West Bank. It has closed much of its vast network of checkpoints, completely cutting off cities, towns, and villages from each other. The fourth practice that characterizes Israel occupation is its discriminatory and unlawful violence. Israeli forces and Jewish Israeli settlers, often with the support of the state, use violence to crush even non-violent resistance to the occupation and to perpetuate a climate of fear and repression. Israeli violence has been part of the fabric of life for Palestinians even before the beginning of the occupation in 1967, and Gaza has always paid the highest price. In the 15 years before October 7, Israeli military campaigns killed 5,365 Palestinians in Gaza, the majority of whom were undisputedly civilians. Of course, this is shocking statistics pales in comparison to what we have in the past 4 months. At the same time, the court cannot ignore the ever-worsening situation in the West Bank. Since October 7, 397 Palestinians have been killed across the West Bank, and 453 have been injured. Even before October 7, 234 Palestinians were killed in 2024, which was the highest number on record. Civilian casualties are not just collateral damage in Israeli attacks. They are the main target. The use of warplanes, armed drones, attack helicopters, and missiles was once unprecedented in the West Bank. Now it is routine. Mr. President, members of the court, Israel's victims are often children. They include 5-year-old Ruqayya, who was shot in the back by Israeli forces on January 7th at a military checkpoint in the West Bank. Her body was withheld from her family by Israeli forces for 10 days. Just last week, Israeli forces also shot 16-year-old Nahil in the head, killing him as he was leaving school. Nahil was the 100th Palestinian child killed by Israeli forces in the West Bank since October 7. This brings me to the fifth practice implemented by Israel, which is its discriminatory military legal system in the OBT. This system privileges Jewish Israeli settlers while depriving Palestinians of the most basic legal protections. A pillar of this system is the practice of indefinite administrative detention of Palestinians without charges. As we detailed in our written statement, this practice was widespread before October 7. Its use has increased excessively since then, in what some rights groups have characterized as mass enforced disappearances. In the past 4 months alone, thousands of Palestinians have been placed in administrative detentions. In Gaza, they are rounded up, blindfolded, disrobed, humiliated, and detained in mass makeshift outdoor prisons. You can find detailed reporting at tabs 5 and 6 of your folders. In the interest of time, I will not detail the 3 remaining policies and the practices that characterize Israel's occupation, which are discussed in Chapter 2 of Qatar's written statement. These practices are 6: the eradication and suppression of all manifestations of Palestinians' culture and religion in the OBT. 7th, the economic oppression of Palestinians and the exploitations of the OBT's natural resources. And 8, the systematic persecution and suppression of all those who attempt to document or pursue accountability for the occupation, such as human rights organizations and journalists. This includes Al Jazeera, Shireen Abu Akleh, who was murdered by Israeli forces on May 11, 2022. Mr. President, members of the court, these 8 discriminatory practices and policies are among those that the court is called upon to assess in answering question A. Viewed jointly, they reveal the true nature of the occupation as an illegal settler colonial regime. I will turn now to the final portion of Qatar's presentations concerning the legal status of the occupation and the response to question B. Mr. President, member of the court, the written statements and comments that addressed in question B overwhelmingly endorsed a finding by the court that the Israeli occupation of the OBT is illegal. This was the express conclusion of at least 38 participants in these proceedings, with at most 2 states reaching the opposite conclusion. Those participants finding that the occupation is illegal offered a number of lines of analysis to support their shared conclusion. This is unsurprising. Israel's occupations has violated so many fundamental principles of international law that it would be hard to point to just one reason for its illegality. In Chapter 3 of Qatar's written comments, we identified 5 main reasons as to why Israel's occupations of the OPT is illegal. With its written comments, Qatar also submitted a detailed appendix compiling relevant statements by participating states and organizations. These can be found at tabs 7 to 15 of your folders. We hope that Qatar's analysis will be helpful for the court's work. I shall briefly walk the court through 5 reasons for the illegality of the occupation. First, the occupation contravenes the Jus Cogens obligation to respect the right of self-determination of the Palestinian people. 39 states and international organizations found that the occupation violates the right of self-determination. 28 of those participants underscored that the occupation has become illegal for this reason. Second, Israel's occupation also violates Jus Cogens' prohibition of apartheid. 25 participants endorsed a finding of apartheid. Among those reaching this conclusion, 16 participants underscored that the situation of apartheid renders the occupation itself illegal. Third, Israel's occupation is illegal because it violates Jus Cogens' prohibition on the use of force. This was the conclusion of 18 participants. Fourth, by virtue of its illegal annexation of portion of OPT, Israel has breached yet another Jus Cogens norm, the prohibition on the acquisition of territory through the use of force. At least 41 participants in the proceedings have pointed this out, with 31 of them underscoring that the occupation is illegal as a whole because Israel's annexation of the OPT is an integral feature of the occupation. Fifth and finally, Israel's occupation is illegal due to the fact that it's not of a temporary character, not being carried out in good faith, or not being administered in the best interest of the occupied population. 17 states reach such conclusions. Mr. President, members of the court, the state of Qatar endorses all of these arguments for the illegality of the occupation. While it's of course for the court to decide how best to answer the General Assembly's questions be, it is Qatar's respectful submission that the court should not limit itself to choosing only one of these grounds for illegality. Unlike contentious cases, judicial economy does not support the adoption of only the narrowest reasoning possible in these proceedings. To the contrary, in the context of an advisory opinion, the court's function is to provide legal advice to the organ requesting the opinion. There are multiple relevant legal regimes applicable to the situation, and the court's advice on each of these frameworks will be of immense value to the General Assembly and to the international community at large. In this connection, Qatar and many other states attach particular importance to a finding that Israel's occupation by its nature amounts to a regime of apartheid. A finding of apartheid is not just the most accurate label for what the occupation has become. It also provides a tangible but a flexible roadmap for what must come next. What ending apartheid requires is achieving a solution, achieving a situation in which all people, Israeli and Palestinians, equally enjoy their fundamental human rights and dignity. With the requisite finding of apartheid by the court, the international community, including the General Assembly, can activate similar mechanism for bringing about an end of the occupation as it did with the apartheid regime in South Africa. This is the surest path to truth, justice, and yes, reconciliation. Mr. President, members of the court, the people of the world are looking at you. We are confident that you will seize this historic opportunity to finally bring to an end a century of injustice against the Palestinian people. I thank you for your kind attention.
I thank the delegation of Qatar for its presentation, which brings to a close this morning's hearing. The court will meet again this afternoon at 3 p.m. to hear the United Kingdom, Slovenia, Sudan, Switzerland, the Syrian Arab Republic, and Tunisia. The sitting is adjourned. Please be seated. The sitting is open. For reasons duly made known to me, Judge Abraham is unable to join us for this afternoon sitting. The court meets this afternoon to hear the United Kingdom, Slovenia, Sudan, Switzerland, Syrian Arab Republic, and Tunisia on the questions submitted to it by the United Nations General Assembly. I recall that each of the delegations has 30 minutes for its presentation. This afternoon, the court will observe a short break after the presentation of Sudan. I shall now give the floor to the representative of the United Kingdom, Ms. Sally Langrish. You have the floor, Madam.
Thank you. Mr. President, members of the court, it is an honour to appear before you on behalf of the United Kingdom. In participating in these proceedings, the United Kingdom underlines its respect and continued support for the court. Our position on the Israeli-Palestinian dispute is long established. We firmly believe that a negotiated two-state solution is the only way to end Israel's occupation, to deliver Palestinian self-determination, and to preserve Israel's identity and security. That belief is founded on the relevant Security Council resolutions and the parties' existing agreements. Recent events only reinforce the importance and urgency of implementing the existing framework. On the 7th of October, Israel suffered the worst terrorist attack in its history. Hamas's terrorist attacks and the ensuing conflict in Gaza have resulted in tragic and large-scale loss of life and injury to civilians. Palestinians now face a desperate humanitarian crisis in Gaza. The United Kingdom wants to see an immediate suspension of the fighting in Gaza and then progress towards a sustainable and permanent ceasefire. It is essential to ensure irreversible momentum towards a two-state solution, guaranteeing security, justice and peace for both Palestinians and Israelis. The United Kingdom has only addressed matters of propriety in its written statement rather than the merits of the request. It takes the same approach in these oral submissions. In doing so, the United Kingdom should not be taken to accept any factual allegation or legal proposition advanced by other participants. Over the course of this week, we have heard certain characterizations of Israel's actions which we don't accept. We have also heard characterizations of our own conduct and the motivation for it, which we emphatically reject. We are confident that the court will find analogies with unrelated cases to be entirely unhelpful. What matters is the case before it today. The United Kingdom confines its submissions to relevant matters of legal principle, firmly founded on the court's own jurisprudence. We submit that the terms of the request do not allow the court to give an opinion in a manner consistent with its judicial functions. The United Kingdom will focus today on 3 key points concerning propriety, which will be developed by Professor Saroushi. They are: first, the impact of the non-circumvention principle in this case. Second, the unsuitability of the fact-finding exercise that the court would have to conduct to answer the request as presently framed. Third, the effect of Security Council resolutions 242 and 338. Each of these points independently provides a cogent reason for declining to answer the request. The court will have observed that our third reason has occupied a particularly prominent place in the participants' oral submissions. Should the court be minded to issue an opinion, then the United Kingdom would respectfully urge it to reformulate the questions to concentrate on the Security Council framework. In this scenario, the court should focus on assisting the General Assembly in supporting urgent progress towards a negotiated solution. I will address this point in concluding the United Kingdom submissions later. But first, Mr. President, I invite you to give the floor to Professor Saroushi to address the issues of propriety.
Thank you, Ms. Langridge. I now give the floor to Professor Saroushi. You have the floor, sir.
Mr. President, members of the Court, it is an honour to appear before you on behalf of the United Kingdom. I shall first address the non-circumvention principle. The Court's jurisprudence has long recognised the distinction between its advisory and contentious jurisdictions. The Court has held consistently that its advisory jurisdiction cannot be used to undermine the fundamental requirement of state consent. Further, it should not provide a form of judicial recourse for parties, nor should the Court resolve disputes between parties using its advisory jurisdiction. Instead, the Court's advisory function is to offer legal advice to the UN organs requesting the opinion in order to assist them in their activities. Let me be clear. The United Kingdom does not submit that a state whose rights or duties may be affected by an opinion can prevent the Court from giving an opinion. Rather, consistent with the Court's jurisprudence, the United Kingdom's submission is that where a request is, I quote, directly related to the main point of a dispute between two parties, then the Court should refrain from giving an opinion. In the words of the Court in Western Sahara, to give an opinion in such a case, I quote, would have the effect of circumventing the principle that a court is not obliged to allow its disputes to be submitted to judicial settlement without its consent. Close quote. If the Court were to answer the request as currently formulated, it would entail a breach of the non-circumvention principle. The United Kingdom makes 4 points. The first relates to the nature and content of the bilateral dispute. It is more than a mere difference of views. It is a dispute of acute sensitivity. It is long-standing. It concerns the status of Israel's occupation, issues of security, and the conditions under which Israel can and should withdraw from the occupied Palestinian territories. Second, the request engages that core dispute. The General Assembly asks the Court to consider in express terms and rule on both the legal status of the occupied territories and the legal consequences of that status. The Court is also invited to make findings of Israeli responsibility in relation to its policies and practices. This engages key permanent status issues which are at the heart of the Israeli-Palestinian dispute, including on Jerusalem, on settlements, on security arrangements, and on borders. Indeed, a key participant has described the Assembly's request as taking the entire Palestine question to be looked at by the highest court in the globe. The third point concerns the relief requested. The Court is asked to determine that Israel's occupation is unlawful and to order that Israel should withdraw immediately from the occupied territories as a result. Over the course of this hearing, the Court has repeatedly been requested to order Israel's immediate, unconditional and total withdrawal. This repeated insistence further demonstrates that the Court is being asked to decide the main point of the dispute, which several states recognise. Finally, Israel has not consented to the main points of the dispute being resolved by this Court. To the contrary, it has asked the Court to refuse to respond to the request. Given the content of the request as currently formulated, there is thus no basis on which the Court should answer it. Participants have identified 2 main counter-arguments as to why the Court should proceed to answer the request. First, they say the court can determine key issues relating to the parties' bilateral dispute because it is of broader concern to the UN. Their argument relies on the court's recognition in the Wall opinion that the General Assembly has a permanent responsibility towards the question of Palestine. The result, they say, is that the request arises, quote, in a much broader frame of reference than a bilateral dispute. With respect, the United Kingdom disagrees. The General Assembly's consideration of a bilateral dispute does not mean that the non-circumvention principle is inapplicable. If it did, the principle would never apply in any advisory proceedings, since any bilateral dispute on which the Assembly made a request would always fall within the so-called broader frame of reference. Such an approach would deprive the non-circumvention principle of all practical application. This approach to the United Kingdom is consistent with the Wall opinion. That opinion did not concern the core aspects of the Israeli-Palestinian dispute. The court itself accepted that it could not properly address what it referred to as the greater whole of the dispute. Judge Higgins characterised that approach as wise and correct. Judge Karoma was careful to distinguish the request in the Wall case from any such broader request that concerned the Israeli-Palestinian conflict as such or its resolution. And Judge Awada accepted that the court's answer should not, quote, be tantamount to adjudicating on the very subject matter of the underlying concrete bilateral dispute that currently undoubtedly exists between Israel and Palestine. A related point that several participants have advanced is that the Israeli-Palestinian dispute is multilateral in character because it concerns erga omnes obligations. The fact that a bilateral dispute may involve obligations in which states have a collective interest does not obviate the need for consent for that dispute to be resolved before the court. Nor does it change the fact that there are two participants involved in that bilateral dispute. The second counter-argument on non-circumvention is that the non-binding nature of advisory opinions means that a court can opine on a bilateral dispute. Like the first argument, this would deprive the non-circumvention principle of all practical application. By definition, Mr. President, all advisory opinions are non-binding, and so the principle would never apply in any advisory proceedings. This ignores that the court is being asked to make findings about Israel's liability and responsibility for various alleged breaches of international law that are central to the bilateral dispute. The court would in substance be deciding on the main points of the dispute if it were to answer the request as formulated. And that is precisely the problem that the non-circumvention principle is intended to avoid. This submission also ignores that serious legal consequences may result from the court's findings. This risk is even more pronounced since several participants asked the court to make legal determinations for the express purpose of clarifying the law relevant to the parties' negotiations. In sum, the principle of non-circumvention is engaged in this case. Mr. President, members of the court, if this fundamental legal principle is ever to have any real meaning or application, the court must decline to answer the request as currently formulated. I now turn to the United Kingdom's argument concerning the court's factual inquiry. Let me be clear. The United Kingdom is not questioning the court's competence to make factual findings. The court can, of course, do so, and the United Kingdom does not suggest otherwise. Nor is there any doubt that the information and evidence available to the court is voluminous. Rather, it is the sheer scale and complexity of the factual determinations that would need to be made by the Court in these advisory proceedings which is the problem. The United Kingdom is not the only participant to raise this issue. Allow me to highlight a few features of the factual determination process in this case. The request in the present case makes no attempt to set out its factual basis. This stands in stark contrast to the Wall opinion. In that case, the request by the General Assembly was based on assumed facts described in a single report by the UN Secretary-General. As one key participant accepts, and as the Court's jurisprudence reflects, this means that it is for the Court, in exercising its judicial function, to independently evaluate the factual materials that have been submitted to it. In this case, the request asks the Court to determine a long list of legal issues and make the necessary factual findings to support them. This is by reference to the entire factual record stretching back some 57 years and the UN dossier spanning nearly 30,000 pages. As a matter of practicality, it is unclear how the Court can properly make the broad range of findings required to answer the request and consider such a volume of material, especially when exercising its advisory jurisdiction, where the Court cannot fall back upon considerations of burden of proof. It is no answer to assume that the Court can defer to the reports of UN bodies. The Court must reach its own independent findings of fact. We emphasise that several states, including the United Kingdom, have expressed reservations about these UN reports. The Court's task is further complicated by a factual landscape that's rapidly shifting in the context of an ongoing and active conflict. This creates the serious risk that the Court may draw legal conclusions on an incorrect factual basis. The problem is further heightened by the gravity of the accusations levelled against Israel, where it is not a party and where the proceedings have been expedited. As this Court has long recognised, quote, claims against the state involving charges of exceptional gravity must be proved by evidence that is fully conclusive. In sum, the United Kingdom submits that there is a serious risk that the Court may undermine its judicial function by giving an advisory opinion in such a context. Mr. President, members of the Court, I now turn to the existing framework, the third point, for resolving the parties' dispute and its impact on these proceedings. The Court is well aware of the agreed framework for a permanent settlement of the parties' disputes as contained in Security Council Resolutions 242 and 338 and in the parties' interim agreements. The precise terms of Resolution 242 are worth recalling. They identify the two interdependent principles of withdrawal and security, to which the Court was referred on Wednesday. To be clear, this resolution does not determine that the occupation is unlawful. The terms of the resolution make this plain. The Security Council and the General Assembly continue to endorse this framework. Most recently, in December 2023, the Council affirmed its unwavering commitment to a two-state solution. Both organs also continue to recognise that a permanent settlement requires a negotiated solution under the auspices of the UN. Many states in these proceedings have emphasised the need for a negotiated solution and the importance of preserving the agreed framework in the context of these proceedings. The United Kingdom shares these views. The parties' agreed framework provides a further basis for declining to answer the request. That framework envisages the negotiation of Israel's withdrawal, not a court decision requiring it. In response to this submission, three main points have been raised by other participants. First, it is said the negotiation process has been stalled for some time. This does not negate the validity of the Security Council framework, nor does it change the reality that a negotiated solution under the UN's auspices is the only possible way in which the conflict will be resolved. It underscores the need to strengthen that process rather than undermine it. Second, some participants have referred to the court's jurisprudence on whether it should take account of adverse political consequences when considering propriety. The court's jurisprudence requires there to be an objective basis to assess the relevance of such consequences. In this case, there is an objective basis. It is the established Security Council framework. The General Assembly's general mandate in respect to the Palestinian question cannot override the Security Council framework. Third, it is argued that an opinion will not interfere with the Security Council framework or with negotiations conducted under its auspices. Instead, it is claimed an opinion will assist that process. Participants rely on the court's statement in the Wall opinion that the negotiations must be conducted in accordance with international law and equivalent language in Council resolutions. And so the court's legal conclusions can and should, they say, constrain the bases on which those negotiations are conducted. With respect, Mr. President, this argument is flawed. It would undermine the very premise of the Council's framework if the court were to address the status of the occupation and require Israel's withdrawal. As I observed earlier, that framework inextricably links withdrawal with security and applies on a reciprocal basis. An unconditional order directed at only one party contradicts that fundamental requirement. It also undermines the additional premise that Israeli withdrawal will be achieved by negotiation rather than by court opinion. Furthermore, an opinion addressing the parties' obligations would prejudice their negotiating positions and thus contravene the court's injunction in the interpretation of peace treaties and the Western Sahara advisory opinions. That, I quote, "the legal position of the parties to a dispute cannot be in any way compromised by the answers that the court may give to the questions put to it." For these reasons, the United Kingdom respectfully requests the court to decline the request as presently formulated. Mr. President, I now invite you, please, to give the floor back to Ms. Langrish.
I thank Professor Saroushi. I now give the floor back to Mrs. Langrish. You have the floor, Madam.
Thank you, Mr. President, members of the court. So Professor Saroushi has explained why the court should decline to answer the request. But if the court is nonetheless minded to provide an opinion, the United Kingdom proposes an alternative course, which seeks to respect the existing framework and ensure the parties' compliance with it. We foreshadowed this approach in our written statement. It is firmly rooted in the court's jurisprudence. Let me start by recalling the court's recognition in the Wall opinion that the resolution of the dispute requires the implementation of Security Council resolutions, in particular resolutions 242 and 338. This, in turn, requires a negotiated solution to the outstanding problems and the establishment of a Palestinian state existing side by side with Israel. Judge Higgins was even more prescriptive. She rightly observed that the resolutions embody key underlying requirements for the resolution of the Israeli-Palestinian dispute, namely that Israel is entitled to exist, to be recognised, and to security, and the Palestinian people are entitled to their territory, to exercise self-determination, and to have their own state. Judge Higgins further recalled that Resolution 1515 of 2003 envisages that these long-standing obligations are to be secured both generally and as to their detail by negotiation. Her view was that the court, and I quote, should have used the latitude available to it in an advisory opinion. And she reminded both parties not only of their substantive obligations under international law, but also of the procedural obligation to move forward simultaneously. The United Kingdom's position on the principles for the implementation of Resolutions 242 and 338 has long been clear. First, there must be an agreement on the borders of the two states based on the June 1967 lines with equivalent land swaps between the parties. Second, security arrangements for the Palestinians must respect their sovereignty, and for Israel, they must protect its security. Third, a just, fair, agreed and realistic solution to the refugee question must be put in place. And fourth, the aspirations of both parties for Jerusalem must be fulfilled through negotiations on the status of Jerusalem as the future capital of both states. The United Kingdom agrees with those states that urge the Court not to cause prejudice to the existing Security Council framework or to decide any aspect of the parties' bilateral dispute. Like other participants, the United Kingdom recognises that an alternative route to respect propriety is to reinterpret the request or reformulate its terms. There is no question that the Court has the power to proceed in this way. It has often been required to interpret or even reformulate the questions put. As Judge Tomka has acknowledged, the Court can avoid intruding on a bilateral dispute by narrowing the scope of its answer. The question for the Court is how best to achieve these aims. We propose that the Court's opinion should focus on endorsing the continued application of the agreed framework with a view to ensuring its urgent implementation. An answer of this kind would respect the three propriety limitations that we have identified. It would also assist the General Assembly to discharge its mandate on the Palestinian question, which many participants have emphasised is the object of this request. More specifically, the United Kingdom, in this alternative submission, respectfully invites the Court to do the following: to endorse the continued application of the Security Council framework to both parties and the need for its urgent implementation at the earliest possible opportunity, to recall both parties' obligations to respect the terms of the Council's framework, to recall both parties' agreement not to aggravate their dispute by taking any step to change the status or integrity of the occupied territories until a negotiated solution is agreed. And lastly, to reaffirm the parties' obligations in their interim agreements that they negotiate on permanent status issues. In this way, the Court could assist the General Assembly in achieving its stated objective, which is to support urgent progress towards a negotiated solution within the Security Council framework. The United Kingdom reiterates that a negotiated two-state solution is the only way in which the Israeli-Palestinian conflict will be resolved. Mr. President, honourable members of the Court, thank you for your attention. That concludes the United Kingdom's submissions.
I thank the delegation of the United Kingdom for its presentation. I invite the next participating delegation, Slovenia, to address the Court, and I call Mr. Helmut Hartmann to the podium.
Mr. President, members of the Court, it is an honor to appear before you and to do so as a co-agent of the Republic of Slovenia. In the name of the Republic, I wish to extend our congratulations to new members of the Court and to you, Mr. President and Madam Vice President, for your elections. Slovenia has the highest respect for this Court and its important mission to ensure respect for international law on which it is the organ. By its Resolution 77-247 of 30 December 2022, the General Assembly has submitted to the scrutiny of the Court legal questions of fundamental importance for the United Nations and for the international community as a whole. The Republic of Slovenia supported the resolution and the request for an advisory opinion. We are convinced that the advisory opinion of the principal judicial organ will assist the General Assembly and all organs of the United Nations in their efforts and activities concerning the situation in Palestine. As it has been reiterated repeatedly, the United Nations has a permanent responsibility towards the question of Palestine until the question is resolved in all its aspects in a satisfactory manner in accordance with international legitimacy. In its declaration of the current situation in Palestine and Israel, adopted on 23 November last year, the National Assembly of the Republic of Slovenia expressed its hope that the international community, including the United Nations, adopts a more ambitious, responsible and coordinated approach that will constructively support the Middle East peace process, leading to a lasting, peaceful coexistence between two peoples and to a two-state solution. Mr. President, it's hardly need to recall in this great hall of justice that one of the purposes of the United Nations is to bring about by peaceful means and in conformity with the principles of justice and international law, adjustment or settlements of international disputes or situations which might lead to a breach of the peace. International law and its respect constitute the cornerstone of the activities of the organization and of the relations between its member states. As the principal judicial organ of the United Nations, this court's role is to identify existing principles and rules, interpret them and apply them, thus offering a reply to the question arising by the organs of the organization based on law. The questions submitted to your scrutiny concerning the legal consequences arising from policies and practices of Israel are scarcely susceptible of a reply otherwise than on the basis of law. The legal principles and rules upon which the court is asked to provide an advisory opinion constitute some of the most basic foundations for a peaceful, just, lasting and comprehensive solution to the question of Palestine. The Republic of Slovenia is fully committed to these fundamental principles, ensuring a consolidated multilateral system based on an effective United Nations organization, the sovereign equality of states, collective security, the peaceful settlement of disputes, the self-determination of peoples, high human rights standards, and a powerful rule of international law. We are mindful that a comprehensive solution needs to be achieved through meaningful negotiations aimed at the complete end of the occupation of the Palestinian territory and a resolution of all status issues. It is deeply concerning that despite the efforts of the United Nations and the numerous resolutions of the General Assembly and the Security Council, negotiations have been stalled. As we speak, the prospect of the mutual agreed solution seems to be more and more uncertain. The situation in the region is alarming. Therefore, more than ever, it is indispensable for the organization and for the international community to take and to encourage all efforts that, with a view to achieving as soon as possible, on the basis of international law, a negotiated solution to the outstanding problems and the establishment of the Palestinian state existing side by side with Israel and its other neighbors, with peace and security for all in the region, as the court emphasized in its 2004 advisory opinion. The Republic of Slovenia, through the voice of its National Assembly, reaffirmed its unwavering support for a negotiated two-state solution on the basis of the 1967 borders, resulting in two sovereign democratic states living together in peace and security in full respect of international law. However, Mr. President, the need for negotiations aimed at the mutual agreeable solution or the existence of the framework for such negotiations are not compelling reasons that should lead the Court to decline the request for an advisory opinion. On the contrary, further clarifications in respect of relevant legal principles, rules and responsibilities can only contribute to a solution on the basis of meaningful negotiations, international law and the rule of law. The Court recalled in 1996 and 2004 that it is, and I quote, aware that no matter what might be its conclusion in any opinion it might give, they would have relevance for the continuing debate on the matter in the General Assembly and would present an additional element in the negotiations on the matter. End of quotation. In this regard, the questions asked by the General Assembly are relevant and have a practical effect guiding the United Nations, its member states, and those most directly involved in respect of the legal implications that need to be taken into account for achieving a lasting, comprehensive and just solution through peaceful means, and particularly through negotiations, is plenty part of the Court's judicial function. As a court of law, as a world court, you are entitled to pronounce on legal questions that will and must drive, frame and facilitate further actions and negotiations aimed at a full and complete settlement of the questions of Palestine. Mr. President, the Republic of Slovenia considers that nothing prevents the Court to address the request of the General Assembly in law and in fact. As I have already recalled, the questions are legal ones. The Court is asked to opine upon the legal consequences arising from policies and practices of Israel. It is thus for the Court to assess whether these policies and practices are in breach of rules and principles of international law, and on this basis clarify the legal consequences of these violations. Moreover, the record before the Court and the information publicly available contains sufficient information and evidence enabling the Court of properly assessing the questions of fact that are relevant and necessary for answering the legal questions before it. Mr. President, members of the Court, I thank you for your attention. Mr. President, may I kindly ask to give the floor to Dr. Daniel, who will continue the presentation of the Republic of Slovenia.
I thank Mr. Hartmann.
So I now invite Dr. Daniel Müller to the podium. You have the floor, sir. Yes, thanks very much. Mr. President, distinguished members of the Court, it's a great privilege for me to appear before you and to do so to assist the Republic of Slovenia. Given the time at my disposal, it's scarcely conceivable to respond to all the aspects of the two questions addressed by the General Assembly in its Resolution 77247, so I'm going to stick to 2 points. First, the relevant rules and principles of international law to respond to the questions posed, and inter alia those relating to the right of the Palestinian people to self-determination. Then, secondly, I'll look at the legal consequences arising from the violations of these rules and principles of international law, inter alia for Israel, but perhaps all for all the other states and for the United Nations. I'll do with these 2 points seriatim. Mr. President, the right of the Palestinian people of self-determination, specifically mentioned in the first question posed by the General Assembly, is not open to dispute. Your Court has already underscored in your advisory opinion of 2004 that the existence of a Palestinian people is no longer an issue, and that among the legitimate rights of the Palestinian people is that of self-determination. A people's right to self-determination is not just some random right, Indeed, as of 1945, the importance of this right has justified its inclusion in the Charter among the objectives of the organisation and side by side with the principle of the equal rights of peoples. The General Assembly subsequently confirmed in 1960 that, I quote, all peoples have the right to self-determination and that the subjection of peoples to alien subjugation, domination and exploitation constitutes a denial of fundamental human rights, is contrary to the Charter of the United Nations, and is an impediment to the promotion of world peace and cooperation. The two covenants that Israel signed as of 1966 and to which it's a party since 1992 also reaffirm that all peoples have the right of self-determination and thus may freely determine their political status and freely pursue their economic, social and cultural development. So the right of peoples, of all peoples, to self-determination is not only one of the essential principles of contemporary international law, it is also a fundamental human right having a broad scope of application. Your court has recognised that the obligations arising from this essential right are erga omnes obligations. Now, as the co-agent has recalled, the Republic of Slovenia is particularly committed to this right. The people of Slovenia were able to exercise it in circumstances which the court will know well, in order to freely establish its own sovereign and independent state. Given its history, the Republic of Slovenia is persuaded that the right to self-determination is an essential and indispensable pillar of the international legal order. More recently, Slovenia has supported the incorporation by the International Law Commission of a non-exhaustive list of peremptory norms in its draft conclusions of 2022. And this list includes, as you well know, the right to self-determination. Now, to this day, the Palestinian people has been unable to fully exercise its inalienable right to self-determination. Indeed, Israel, the occupying power for many decades, is actively preventing the full realization of the Palestinians' right to self-determination in compliance with the guarantees and principles of international law. The occupation of Palestinian territory, its colonization and its fragmentation constitute not only a flagrant violation of the prohibition of the acquisition of territory by force, but also is a considerable impediment to the realization of a free and independent Palestinian state. The court recalled quite rightly that the peoples of non-self-governing territories are entitled to exercise their right to self-determination in relation to their territory as a whole, the integrity of which must be respected by the administering power. As a consequence thereof, any modification of the territorial base to which a people is entitled by right of self-determination, as well as the de facto and de jure annexation by Israel of a considerable part of Palestinian territory, are by their very nature contrary to international law. The need for respect and preservation of the territorial unity, contiguity and integrity of all of the occupied Palestinian territory, including East Jerusalem, recalled once again by the General Assembly in December last year, constitutes an essential condition for the Palestinian people to fully realize its right to self-determination and exercise its sovereignty over its territory. Thus, as the Council for Human Rights has recalled, the Israeli settlements fragmenting the West Bank, including East Jerusalem, into isolated geographical unit determination. Mr. President, the right of the Palestinian people to self-determination is fundamentally hobbled by the prolonged occupation of Palestinian territory by the occupying power. and by the non-compliance with the obligations incumbent upon that power under the elementary rules of international humanitarian law. Palestinian territory remains under occupation within the meaning of international humanitarian law. The Court established in its advisory opinion of 2004 that on account of this de facto situation, the relevant customary and conventional rules of international humanitarian law are applicable in occupied Palestinian territory, including East Jerusalem. So, international occupation law is based on the idea that occupation may only be a temporary and provisional situation. The occupying power does not acquire sovereignty over the territory it occupies and must administer it, taking due account of its specific legal status. It must abstain from taking measures likely to entail permanent change, be they the extent of the territory occupied or to its social, economic and demographic reality. More generally, the occupying power must not exercise its authority in order to promote its own interests or with the aim of using the inhabitants, their property or the resources of the occupied territory for its own benefit. The occupying power must ensure the protection of the population subject to occupation and take the necessary measures in order to respect their rights and ensure their implementation. Above all, that includes the fundamental rights guaranteeing dignity, equality, and the value of the individual. Rightly, the Court confirmed in 2004 that the treaty instruments relative to human rights remained applicable in OPT, and thus must be respected vis-à-vis the men, women, and children of Palestine. The practices and policies implemented by the occupying power in occupied Palestinian territory do not comply with the elementary obligations of international human rights law or international humanitarian law. The Court already confirmed this in 2004 with respect to the construction of the wall. However, the colonization of occupied Palestinian territory, including East Jerusalem, and the installation of settlements with the aim of achieving lasting demographic change, and the displacement of Palestinians, the destruction of their houses and their property, have but accelerated. The Court, the General Assembly and the Security Council have recalled that settlements in occupied Palestinian territory have no legal basis and remain illegal. The Council vigorously regretted for a long time the continuation and persistence of Israel in pursuing those policies and practices. The written and oral statements of participants in the instant advisory proceedings have also demonstrated that the practices and policies of the occupying power are not consistent with what is required of it under international law. All these violations of international law arising from the prolonged occupation compromises the effective exercise by the Palestinian people for its right to self-determination and the achievement of a two-state solution, to which the Republic of Slovenia remains profoundly committed. Distinguished members of the Court, every internationally wrongful act of a state entails the international responsibility of that state. That key provision of the Articles on State Responsibility for Internationally Wrongful Acts contains in itself a part, an important part indeed, of the answer to the question of the legal consequences of the policies and practices which are before you. Israel has engaged its international responsibility. The content of the international responsibility of the State of Israel, or to use the terms of the ILC, the legal consequences involved by this responsibility, are enumerated in Articles 29 through 32 of the Articles on State Responsibility. Israel has the obligation to put an end to its internationally wrongful acts and to all the practices preventing the Palestinian people from fully exercising its right to self-determination, first and foremost of which are the prolonged occupation and annexation of Palestinian territory. Israel must fully carry out its international obligations, in particular its obligation to respect and promote the self-determination of the Palestinian people in the full compliance with international law. The harm caused by these internationally wrongful acts must be fully repaired. Implementation and compliance with these applications arising from the wrongful acts are not only due to Palestine and to the Palestinian people. On account of the erga omnes nature of the rules and obligations breached, which rules are due to the international community as a whole, any state without distinction is entitled to invoke Israel's responsibility. Any state can require the cessation of violations and compliance with the obligations in question. Any state is entitled to require the implementation of the obligation of reparation in the interest of the Palestinian people and the state of Palestine. As the court recalled in the Barcelona Traction case, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection. Mr. President, as far as states other than Israel are concerned, and doubtless the United Nations too as an international organization, this isn't merely about summoning Israel to cease its wrongful acts. States do not only have a legally protected interest that Israel respects the right of the Palestinian people to self-determination. All states also have the duty, and the duty is to promote, through joint and separate action, realization of the principle of equal rights and self-determination of peoples in accordance with the provisions of the Charter, and to render assistance to the United Nations in carrying out the responsibilities entrusted to it by the Charter regarding the implementation of the principle. And that is rehearsing, you will have noted, the terms of Resolution 2625 of the General Assembly. In the same fashion, under the terms of Article 1, which is shared in all the 4 Geneva Conventions, the contracting states not only committed to respect the obligations arising from these treaties, but also to ensure respect of these obligations in all circumstances. The practices and policies impeding the realization of the right to self-determination of the Palestinian people cannot exempt the other states and the United Nations from these obligations. On the contrary, in the presence of the illegality of these practices and policies noted time and again by the principal organs of the United Nations, including your court, we must be able to count on the members of the United Nations to draw all attendant consequences and to implement the obligations falling to them pursuant to the Charter and international law. So that would imply for all states and for the United Nations to take the necessary measures to put an end to the tragic and above all illegal situation facing the Palestinian people, and which has faced them over decades. The General Assembly has recalled time and again and has urged all states and the specialized agencies and organizations of the UN system to continue to support and assist the Palestinian people in the early realization of their right to self-determination, independence and freedom. Furthermore, on account of the nature of the obligations in issue and their importance, states are not only held to cooperate to bring an end through lawful means these serious breaches, they are also under the obligation to not recognize the situation created by these breaches and must abstain from rendering any aid or assistance in maintaining this situation. The Court has already confirmed the relevance and existence of legal consequences for all states in its 2004 advisory opinion, and the General Assembly has requested all states members of the United Nations to comply with their legal obligations as mentioned in the advisory opinion, including those consistent with their obligations under international law and the relevant resolutions not to recognise and not to render aid or assistance in maintaining the situation created by measures that are illegal under international law, and to not aid them in this end. In order to comply with these obligations, all states must inter alia distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. As the Security Council recalled in its Resolution 2334 of 2016, referring all the while to your advisory opinion. Mr. President, distinguished members of the Court, the painting by Paul Albert Besnard, which hangs in this great hall, recalls the cardinal principle of contemporary legal order: peace by justice. The Republic of Slovenia is firmly convinced that the scrupulous respect of international law, where the court is the principal judicial organ, can put an end to the unbearable and unacceptable situation in the region and work for a just and lasting peace in which every state in the area can live in security. Mr. President, these words close the oral presentation of the Republic of Slovenia, and on behalf of our delegation, I would like to thank you for your kind attention.
I thank the delegation of Slovenia for its presentation. I invite the next participating delegation, Sudan, to make its oral statement before the court and call upon Mr. Marwan Khair to take the floor.
Mr. President, distinguished members of the Court, it's my honor and privilege to address the International Court of Justice on behalf of the Republic of the Sudan. I express gratitude to this Court for extending the opportunity for my country's participation in these advisory proceedings on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. The Sudan is present here today, owing to the profound significance of these proceedings in the context of realizing the inalienable right of the Palestinian people to self-determination. This matter has persisted on the United Nations agenda for several decades. The dire circumstances prevailing in the occupied Palestinian territory over the past decades, compounded by the current severe humanitarian crisis in Gaza Strip, underscore the profound jeopardy facing the fundamental rights of all people in the Middle East, particularly the Palestinians. Therefore, these oral proceedings assume critical importance in persuading the Court to exercise its jurisdiction and accept this request for an advisory opinion. The Sudan contains that such a stand by the principal judicial organ of the United Nations would convey a definitive message to both Israel and Palestine, urging them to redouble their efforts in achieving peace and security for the mutual benefit for their peoples. Moreover, the Sudan maintained the perspective that, in giving this advisory opinion, the Court would assume a crucial role in fostering justice, peace, and security, not only in Israel and Palestine, but also in the Middle East and beyond. Mr. President, in accordance with the rules of court, we will address the statement specifically to the issue that, from the perspective of the Sudan, remains a point of contention among the participants in these proceedings, whether or not the court should give the requested advisory opinion. The statement will be as succinct as possible within the limits of what is necessary for adequate presentation of the Sudan's contention at this hearing. Mr. President, I respectfully invite you to give the floor to Professor Raimondo, who will proceed with the delivery of this oral statement. Thank you, Mr. President. Thank you, members of the court.
I thank Mr. Khair. I now give the floor to Mr. Fabian Raimondo. You have the floor, sir.
Mr. President, distinguished members of the court, it is my privilege and pleasure to stand before the International Court of Justice today to address the issues of jurisdiction and admissibility of this request for an advisory opinion. The articulation of objections to the admissibility of a request for an advisory opinion from the General Assembly is not an uncommon occurrence in proceedings before this court. Nevertheless, the court has consistently dismissed such objections. In the subsequent discussion, I shall initially recall the consistent jurisprudence of this court on the issues of jurisdiction and admissibility. It is within this body of jurisprudence that the court can find the resolution to the objections raised concerning the admissibility of the current request for an advisory opinion. As pointed out by this court in the Chagos advisory opinion, I quote, "When the court is seized of a request for an advisory opinion, it must first consider whether it has jurisdiction to give the opinion requested, and, if so, whether there is any reason why the court should, in the exercise of its discretion, decline to answer the request." Unquote. The jurisdiction of this court to provide an advisory opinion stems from Article 65, paragraph 1 of its statute. This article provides that the court may give an advisory opinion on any legal question upon the request of any body authorized by or in accordance with the Charter of the United Nations to make such a request. The General Assembly has the authority to request an advisory opinion according to Article 96, paragraph 1 of the Charter of the United Nations, and this article stipulates that the General Assembly has the power to ask the International Court of Justice to provide an advisory opinion on any legal question. In these proceedings, the court is first asked to determine the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and from its adoption of related discriminatory legislation and measures. Next, the court is asked how said policies and practices affect the legal status of the occupation and what legal consequences ensue for all states and the United Nations from this status. Mr. President, members of the court, it is evident that these questions concern the legal consequences of violations of international law that have been recognized as such by the Security Council and the General Assembly, among other United Nations organs and bodies, as well as to the legal status of the occupation in view of those violations and the legal consequences of its illegality. The General Assembly requests the Court to answer these questions in accordance with, inter alia, the rules and principles of international law, international humanitarian law, and international human rights law. For these reasons, the Sudan believes that the request has been made in accordance with the Charter and that the questions submitted to the Court are legal in character. I shall now proceed to the issue of the admissibility of the request. As recalled by the Court in the Chagos advisory opinion, I quote, "The fact that the Court has jurisdiction does not mean, however, that it is obliged to exercise it," unquote. According to consistent jurisprudence of this Court, the discretion whether or not to respond to a request for an advisory opinion exists to safeguard the judicial function of the Court as the principal judicial organ of the United Nations. However, the Court is aware that its reply to a request, I quote, represents its participation in the organization and, in principle, should not be reviewed, end of quote. It is an established jurisprudential principle that this Court may decline to respond to a request for an advisory opinion falling within its jurisdiction only in the presence of compelling reasons. The pertinent query at hand is whether there exists any compelling reason for this Court to decline to respond to the request referred by the General Assembly. Some participants in these proceedings have indeed alleged the existence of such reasons. The grounds most frequently invoked in these proceedings include, firstly, the contention that providing the opinion would prejudice the negotiation process between the parties involved in the underlying dispute. Secondly, the argument that admitting the request would be incompatible with the principle of consent in judicial settlement. And thirdly, the alleged prejudicial nature of the underlying questions and the lack of sufficient factual inquiry. I will now examine the first ground. This ground was raised by Canada, Hungary, Israel, Italy, and Zambia, among others. Thus, for example, in the opinion of Italy, I quote, "An advisory opinion by the court might reduce the flexibility of the parties in dealing with present circumstances and long-term prospects, and therefore would not contribute to move the process closer to a mutually agreed solution." End of quote. This constitutes a type of argument that this court has previously considered in other advisory proceedings. For example, in the nuclear weapons advisory opinion, the court noted that concerns were raised about the potential negative impact of its response on disarmament negotiations. The court acknowledged that regardless of its conclusions, they would introduce an additional aspect to the negotiations. However, the court stated that the ultimate effect of its opinion is a matter of appreciation and cannot be seen as a compelling reason to refuse exercising its jurisdiction. This jurisprudential principle was confirmed by this court in the advisory opinion on the wall. There is an additional, pivotal aspect to address in this context. The two questions central to the ongoing advisory proceedings to the existing conditions in the occupied Palestinian territory. The court is not tasked with determining the content of a final settlement or the precise boundaries of the Palestinian state. Essentially, the request seeks the court to provide an authoritative legal opinion on the current legal ramifications of the practices and policies of Israel referred to in the request. The advisory opinion is expected to bear relevance to extant queries regarding legal status and its associated consequences. Such clarification holds the potential to significantly contribute to establishing the groundwork for a prospective negotiated resolution of the underlying conflict, rather than to endanger the established framework for negotiations that have been suspended for several years now. Hence, the Sudan believes that this does not constitute a compelling reason to decline responding to the request. I shall now address the second ground, the contention that the opinion would circumvent the principle of consent in judicial settlement. This ground was raised by Canada, Fiji, Hungary, Israel, and the United Kingdom, among other participants. For example, Canada objects that, I quote, "It is Canada's understanding that Israel, which has a direct interest in this case, has not provided consent for the ICJ to desist of this matter." End of quote. It is well-established jurisprudence of this court that the lack of consent to the court's contentious jurisdiction by interested states does not impact the court's jurisdiction to render an advisory opinion. This rationale is exemplified by instances such as when the court gave its advisory opinion on Western Sahara, even in the absence of Spain's consent to the request. When it delivered the advisory opinion on the wall, despite Israel not providing consent. And when it issued the Chagos advisory opinion, notwithstanding the absence of consent from the United Kingdom. In each of these instances, the court gave its opinions, even though the request concerned the responsibility of particular states. As this court said in Western Sahara, I quote, "In the present case, Spain is a member of the United Nations and has accepted the provisions of the Charter and Statute. It has thereby, in general, given its consent to the exercise by the court of its advisory jurisdiction." Unquote. In the Sudan's view, the same rationale applies in the current advisory proceedings. The General Assembly has consistently played a crucial role in matters concerning Palestine, as evident from the documentation presented in the Secretary General's dossier before this court. The Palestinian people are yet to realize their right to self-determination, a fact that no state can plausibly contest. Therefore, the Sudan believes that the objection to the General Assembly's exercise of its competence in the realm of self-determination and its consideration of the situation in Palestine is unpersuasive. I shall now address the final ground, the allegedly prejudicial nature of the questions posed by the General Assembly and the lack of appropriate factual inquiry. This ground was raised by Israel in the following terms, I quote, "The tendentious questions placed before the court not only distort the factual reality, they fundamentally misrepresent the legal reality as well." End of quote. In the same vein, another participant in the proceedings, the United Kingdom, posits that the request is inadmissible on the ground that, I quote, "the court cannot be confident that it will have a complete or accurate evidential picture before it." End of quote. Further, in this regard, the United Kingdom contends that, I quote again, "insofar as Israel does not participate in the advisory proceedings by furnishing evidence relevant to the request, the court will lack material explaining the Israeli side of the picture." End of quote. Nevertheless, it is imperative to recall that in the overwhelming majority, if not all, of the opinions rendered by this court, reliance on public information derived, for instance, from United Nations organs or specialized agencies has been a standard practice. In part 2 of the dossier of materials before this court, there are many reports of competent United Nations bodies, such as the Special Rapporteur on the Situation of Human Rights in the OPT, the High Commissioner for Human Rights, and several human rights treaty bodies. Hence, in the Sudan's view, all these reports provide the court with sufficient information on the facts before it to give the requested opinion. Mr. President, members of the court, I express my gratitude for your attentive consideration, and I respectfully invite you to request Mr. Hare to deliver the concluding remarks of the oral statement on behalf of the Sudan.
I thank Mr. Raimondo. I now give the floor back to Mr. Khair. You have the floor, sir.
Mr. President, distinguished members of the court, I wish to emphasize the great significance of the right of peoples to self-determination. In advisory proceedings conducted before this court, wherein the exercise of this right was a pivotal concern, the court's opinion emerged out of fundamental elements shaping the legal framework for resolving the underlying disputes, such as the one concerning Namibia. If only we had a comparable equivalent for Palestine. The successful resolution of the protracted dispute surrounding Namibia can be largely attributed to the court's judicial task. It's respectfully suggested that you should persist in fulfilling that role in the present advisory proceedings. In the light of the foregoing, the Sudan concludes that the court not only has jurisdiction to give the advisory opinion requested by the General Assembly, but also that there is no compelling reason for this court to use its discretionary power not to give the opinion. Thank you, Mr. President. Thank you, members of the court.
I thank the delegation of Sudan for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.
Please be seated. The sitting is open.
I now invite the next participating delegation, Switzerland, to address the court and call Mr. France Perez to the podium. Sir, you have the floor.
Mr. President, distinguished members of the court, it's an honor for me to appear before you on behalf of the Swiss Confederation. The terrorist attacks perpetrated by Hamas and other armed groups on the 7th of October 2023, firmly condemned by Switzerland, and the ensuing violent confrontation in Gaza are today in all our minds. They contribute to polarizing even further positions within the international community and undermine the prospect of a negotiated two-state solution. This potentially makes the task of the court more arduous, but also more necessary than ever. Our presentation will not concentrate on the terrible events of 7th of October and the situation that flows from it, but on the legal questions as posed to the court on 30th December 2022, which relate to the status of prolonged occupation. Israel has legitimate security concerns, but also the obligation to comply with international law. Similarly, the Palestinian people has the right to self-determination with the aim of living in peace, and Palestine has the obligation to respect international law, and fair and lasting solution can only be achieved on the basis of the rules of international law. A good understanding of the content of the obligations under international law is therefore a precondition for negotiating a solution that reflects the legitimate interests of both parties. Thus, it's therefore essential to better understand the legal questions relating to measures taken within the framework of the prolonged occupation of Palestinian territory. The opportunity for the court to provide an impartial response based on international law to the questions posed by the General Assembly and thereby provide a basis for a negotiated solution therefore remains essential. My oral presentation will focus on the specific issues linked to the prolonged occupation under the angle of international humanitarian law and human rights law. Moreover, I'll refer to our written submission of 17 July 2023 and to the developments contained therein. The law of the occupier and the legality of occupation are two distinct questions. The law of occupation applies independently of the question of the legality of occupation. Occupation is a situation that is governed by international humanitarian and human rights law, whereas the legality of it is governed by the UN Charter. The potentially illegal character of an occupation must not call into question the fundamental separation between jus ad bellum and jus in bello. The right of occupation continues to apply in Palestinian territory, irrespective of the question of the legality of the occupation. As such, the prolonged character of an occupation has no incidence on its conformity with jus in bello. No provision of humanitarian law prohibits prolonged occupation. What's more, prolonged occupation remains governed by humanitarian law, supplemented by human rights law, irrespective of a de facto possible annexation. Nevertheless, occupation is understood as a temporary situation. Occupation that is prolonged may lead to a tension between, on the one hand, the obligation for the occupier to maintain the status quo ante, on the other hand, to ensure the well-being of the occupied population. It is this tension and its legal consequences that I'd like to deepen within the framework of this oral submission. To do this, I'll begin by generally addressing the prolonged occupation and the challenges it poses from the standpoint of humanitarian and human rights law. Next, I'll analyze three concrete areas illustrating this tension: the need to interpret and apply contemporary international law in an evolving and systemic manner to ensure protection and well-being of the population. The concrete areas addressed are firstly the legislative administrative competences of the territory, secondly access to items that are indispensable to the survival of the population and protecting dignified life, and lastly, use of force in occupied territory. Allow me, first of all, to address the legal challenges posed by prolonged occupation. The rules of the law of occupation were not developed to regulate situation of occupations lasting several decades. They're based on four fundamental principles that underscore the necessary temporary nature of occupation and to establish a balance between military and humanitarian necessity. Firstly, the occupier doesn't acquire sovereignty over the territory he occupies. Unilateral measures calling into question the territorial status quo are therefore never admissible. A modification of the status of occupied territories can only be envisaged within the framework of a negotiated solution. Secondly, the occupier must maintain the status quo ante and not take measures that might lead to permanent changes, in particular from the social, economic and demographic standpoint. Thirdly, the occupier must maintain security and public order in the occupied territory and administer it in order to ensure the protection and well-being of protected persons. Fourthly, the occupier must not exercise his authority for the purposes of serving his own interests, that of his territory or his population. Within the framework of a prolonged occupation, tensions might indeed appear between these four principles. For example, the well-being of the civilian population might necessitate changes to the status quo. In this context, there's a need to distinguish clearly unlawful situations that undermine the status quo, such as, for example, settlements, from those where the status quo would in fact be maintained to the detriment of the population of the occupied territory. In this case of a prolonged occupation, it is vital that the maintenance of the status quo should not be understood as a freeze on the situation, but as signifying that the populations of occupied territories must continue to be able to live a normal as life as possible in dignity. Occupied territories must not remain frozen in time, but be able to move with their time. To address the legal tensions and challenges specific to a prolonged occupation, it's important to recall the function and the purpose of humanitarian law are to protect and ensure the well-being of the population and not to justify intrusive measures in the interest of the occupying power. The obligation of the occupying power to ensure the well-being of the occupied population calls for an interpretation in favor of the higher interests of the population living under occupation. In order to resolve the tension between the aforementioned principles and better determine the legality of measures taken by the occupier during a prolonged occupation, I suggest three criteria derived from a combined interpretation of humanitarian and human rights law. Firstly, the adoption of specific measures going a priori against the obligation of maintaining the status quo to serve the interests of the occupier is not admissible except for overriding security reasons, and as long as the well-being of the population is not affected in a disproportionate manner over the long term included. Secondly, specific measures running counter to the obligation to maintain the status quo can be adopted if they benefit the population of the occupied territory, consistent with human dignity, and take account of the wishes of the population in the occupied territory and its historical and cultural specificities. Lastly, thirdly, the adoption of such measures is statutory when these measures amount to parallel obligations of humanitarian and human rights law. If humanitarian law was specifically designed to govern situations of armed conflict, it remains that human rights remain fully applicable in situation of occupation. The Fourth Geneva Convention compels the occupying power to assume active responsibility for the well-being of the population under its control. This obligation to protect the population under occupation and to promote its well-being is concretized in the obligation to respect, to protect, and to fulfill the human rights of the occupied population. The characterization under humanitarian law of lex specialis must therefore not be construed as meaning that this law overrides human rights. In principle, there's no direct contradiction between the obligations arising out of humanitarian law and human rights law. On the contrary, humanitarian and human rights law are mutually reinforcing. Thus, Article 27 of the Fourth Geneva Convention requires that the fundamental rights of protected persons be respected in all circumstances. It proclaims the respect of the human person and the inalienable right of its fundamental rights. In the event of prolonged occupation, the relevance of human rights is all the more significant. The logic of humanitarian law is aimed at immediately ensuring the essential minimum needs of the population. This must be supplemented by the need of ensuring over the long term a dignified life. Thus, the balance between humanitarian and human rights law fluctuate with the prolonged character of an occupation. The longer the occupation is prolonged, the more the respect for and guarantee of human rights are important. To close this part, I'd like to stress that all actors exercising de facto control are also bearers of obligations at Israel's side. The practice of UN organs recognizes that, at minimum, an armed non-state actor exercising the governmental type functions or controls, in fact, a territorial population must uphold and protect the human rights of the inhabitants. Palestine, having notably ratified Covenants 1 and 2 of the UN relating to human rights and the UN Convention against torture, has the positive obligation to take all measures in its power and compatible with international law to assure to persons living in these parts of its territory the rights guaranteed by the Convention. Israel and Palestine are under obligation to cooperate and support one another and not to weaken one another in their efforts to ensure the well-being of the population. Victims must also be able to seek reparation for violations or abuse of their rights, whoever the actor at the origin of their grievance, in order to ensure effective respect of human rights. These various actors must cooperate by taking into account that the scale of their obligation will vary notably of the control they exercise and the resources available to them. I come now to the concrete areas, starting with that of legislative and administrative competences of the territory. By virtue of the principle of maintaining the status quo, the occupier cannot take measures bringing about permanent changes, in particular the social, economic and demographic standpoint. The occupier must restore and ensure, as far as possible, public order and safety while respecting, unless absolutely prevented, the laws in force in the country. However, by virtue of Article 64, paragraph 2 of the Fourth Geneva Convention, we can deduce that the occupier might introduce new laws if these are indispensable to ensure A, the security of the occupier, B, order of public life, and thirdly, respect for humanitarian law. Though human rights are not in the exceptions of maintaining local law, an updated reading of humanitarian law requires that their respect be guaranteed. Thus, in the case of prolonged occupation, the obligation to ensure public order and safety implies that the occupier administers the territory in such a way as to ensure protection and well-being of protected persons, not only respect and protect, but also provide them with a right to a dignified life. This, of course, means that he has to move away from the status quo. Mr. President, members of the court, the adoption of measures such as planning, zoning, contradicts the previously mentioned criteria. This regime contributes to put in place a coercive environment, aggravating the risk of forced transfer. Aside from the fact that this regime calls into question the territorial and demographic status quo by promoting Israeli settlements, it cannot be justified under security requirements because it excessively affects the well-being of the population and is discriminatory. In the event of prolonged occupation, the occupier is required, on the contrary, to encourage planning and development of the occupied territory as a priority through local authorities and institutions in favor of the local population. This requires, Mr. President, members of the court, a cooperation with local institutions, support and a strengthening of the latter and not their erosion. I will now turn to the second concrete area, that's to say access to vital goods for the survival of the population and protecting a dignified life. Humanitarian requires that the occupier supplies the population with essentials for its survival. The obligation to restore order and public life must be interpreted broadly and designates the various aspects of the life of the population. The occupier is therefore entitled to make changes going a priori against the status quo as long as they're necessary to improving local life. As indicated above, the conditions of existence of the population under occupation are also governed by human rights, which notably, in a context of prolonged occupation, support and reinforce humanitarian law. The occupier must immediately ensure minimum enjoyment of economic, social and cultural rights and refrain from adopting measures that would limit their exercise. Next, with the prolongation of occupation, the obligation to gradual achievement comes into play. It requires the occupier fully assumes the exercise of these rights in time. Furthermore, by virtue of the right to life, the occupier has the obligation to generate conditions of existence in accordance with human dignity for persons living under his jurisdiction. In the face of prolonged occupation, the economic and social development of the territory may require long-term changes which are opposed to maintaining the status quo. This, of course, creates obligations for Israel as occupying power as well as for Palestinian actors. Mr. President, members of the court, these regressive measures and the use of resources on Palestinian and on occupied Palestinian territory, regressive measures and the use of resources of the occupied Palestinian territory for the needs of the occupier clearly run counter to the previously mentioned criteria. They require modifications of the status quo for the interests of the occupier to the detriment of the Palestinian population. Furthermore, the absence of a gradual realization of human rights is an issue of concern. Lastly, third specific area illustrated in the context of prolonged occupation, the tension between the right of the occupier to guarantee his security, the obligation to ensure the well-being of the population by using the example of the use of force in operations to maintain order. Under Article 43 of the Hague Regulations, the occupier may use force to restore and ensure, as far as possible, public order and safety. However, such a use of force should not be a matter for the conduct of hostilities. Article 43 is but a referral to rules of maintaining order that form part of human rights and the right to life. Maintaining order rests on three principles: necessity, proportionality, and precaution. By way of the principle of necessity, the use of lethal force can only be used in last resort and must pursue an objective goal, such as self-defense or to defend a third party in the event of imminent threat to life. This imminence criteria is strict and cannot authorize use of force preventively. Furthermore, the use of force must always be individualized. A crowd of demonstrators cannot be considered as such as a threat to life. Furthermore, a differentiated use of force must be used if possible. This requires supplying appropriate equipment and weapons for maintaining order, including water cannons, batons, and rubber bullets. By virtue of the principle of proportionality, the degree of force used must be strictly proportionate to the gravity of the offence and the legitimate goal to be reached. Incidental losses are generally not tolerated, and the life of persons who disrupt order must be taken into consideration when weighing up the interest. By virtue of the precautionary principle, law and order operations must be planned with the goal of avoiding the use of lethal force. All this is removed from a logic specific to the conduct of hostility. In the context of occupation that is prolonged, maintenance of order is applied by default. Hybrid situations of civilian and hostile violence must be far rarer than the context of a nascent occupation. Weapons and equipment made available to occupying or security forces must be similar to those which are used by states in peacetime. The use of combat weapons and the use of snipers is even more inappropriate during long-term occupation. The militarization of maintaining order operations must be avoided ex ante when a legitimate legislative and administrative framework must be put in place to regulate the use of force, and the training of Israeli forces must be consistent with international maintenance of order. Ex post, any use of lethal force must be the subject of an actual investigation to ensure accountability, and in the case of proven violations of human rights, there is a requirement to bring those responsible to justice. Israel, as an occupying power, must protect the civilian Palestinian population in the West Bank. The violence exercised by individuals such as settlers towards the population of the occupied Palestinian territory must also be investigated and, where appropriate, subject to criminal proceedings. The positive obligation to protect the population from third parties is an essential component of the right to life. In conclusion, prolonged occupation may a priori give rise to tensions between maintaining the status quo, security of the occupier, and the well-being of the population. These tensions are resolved by humanitarian law, supplemented by human rights law. The longer the occupation, the more respect and guarantee of human rights are important. The joint application of these two legal regimes strengthens the protection of populations living under occupation and may impose specific measures that run counter to the obligation to maintain the status quo. Thus, the development of the territory requires the adoption of positive measures in favor of the population of the occupied territory. Similarly, the well-being of the population requires transformations aimed at improving its conditions of life. Lastly, in the presence of a prolonged occupation, the use of force is presumed to form part of law and order. All parties must prevent violence and the resurgence of hostility in order to guarantee a life as dignified and as normal as possible to the population. In this spirit, Israel and Palestine must cooperate and support one another mutually and not weaken one another or erode the authority of the other party. Mr. President, members of the court, this brings to an end the written submission of Switzerland. Thank you for your attention.
Je remercie la délégation de la Suisse pour son
I'd like to thank Switzerland for their exposé.
Public to address the court and call His Excellency Mr. Ammar Al-Hassan to the podium.
Mr. President, distinguished members of the esteemed court, it is an honor and privilege to address the esteemed court today on behalf of the Syrian Arab Republic at a very sensitive time, while the Palestinian people find themselves with no real protection. In this oral statement, I will present my country's position regarding the questions related to this case in accordance with what was stipulated in the relevant General Assembly resolution. Out of respect for the time allotted to me by the esteemed court, I will get straight into presenting my country's legal position. Mr. President, distinguished members of this honorable court, the theory of occupation in principle contradicts all the values, ethics, laws, and charters that humanity has established throughout its long history. In order to preserve human dignity and sanctity, to maintain international peace and security, and to save the world from the scourges and sufferings of wars. In fact, the crime of occupation has been and continues to be the most serious and heinous crime in the history of mankind, taking into consideration the occupation's flagrant violation of the Charter of the United Nations, the provisions of international law, international human rights law, and international humanitarian law, and all international charters and customary rules. In fact, occupation acts primarily on the basis of usurping land by force, which is essentially prohibited under international law and the provisions of the Charter. It also acts on the basis of suppressing the will of the people, seeking to degrade their dignity and deprive them of their basic rights. Today, the practices of Israel, the occupying power, are definitely the clearest reflection, unfortunately, of the failure of the international community to prevent heinous crime of occupation and to ensure the implementation of the relevant resolutions of Security Council, General Assembly, and the Human Rights Council. The Syrian Arab Republic stresses the need to hold Israel accountable for its grave and continuing violations of the provisions of international law, the Charter of the United Nations and its relevant resolutions, and the provisions of international humanitarian law, including provisions in Section 3 of the Fourth Geneva Convention of 1949, Article 47, and what follows. Mr. President, distinguished members of the Court, we are here today to make sure that they, the occupiers, do not get away with impunity. The first question before the distinguished Court today relates to one of the most important and noble human rights, which is the eternal and fundamental right to self-determination. The right to self-determination is a fundamental human right that is enshrined, among other international instruments and conventions, in Article 1, Paragraph 2 of the Charter of the United Nations, providing that each state shall, and I quote, refrain from any forced action depriving peoples of their right to self-determination, freedom, and independence, end of quote. And that each state shall, again I quote, encourage through joint and unilateral action the realization of the principle of self-determination of peoples, end of quote. This right is also reiterated and affirmed in common Article 1 between the Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, which obliges states that are parties to these covenants to promote the realization and respect of this right in accordance with the provisions of the Charter of the United Nations. Israel violates this right through, for example, the establishment and continued expansion of illegal settlements in the occupied Palestinian territories, including Jerusalem. We note, in particular, the discriminatory Israeli legislation of 2018, or what's so-called the Basic Law, Israel as the nation-state of Jewish people, which recognizes the right to self-determination exclusively for the Jewish people, denying the right of the Palestinian people to self-determination on their land and in their homeland. I shall now turn to talk about the legal consequences. Israel must be held accountable for its violations of international law and United Nations resolutions. Israel must put an immediate end to the violation of its international obligations by halting all actions and measures that prevent and/or impede the exercise of the Palestinian people's right to self-determination, including putting an immediate end of the occupation in all its forms. For third states, since the right to self-determination is an erga omnes argument and obligation on all subjects of international law, all states must respect it and seek to achieve it. it is also the responsibility of all states, consistent with respect for the United Nations Charter and international law, to immediately put an end to the obstruction of the Palestinian people's exercise of their right to self-determination. The United Nations, in particular the General Assembly and the Security Council, should consider the additional procedures and binding international legitimacy tools stipulated in the Charter that are required to put an immediate end to any obstruction preventing the Palestinian people from obtaining their right to self-determination, and to take the necessary measures in order to ensure the implementation of its relevant resolutions without any further delay. With your permission, Mr. President, I shall delve into the part of the question regarding prolonged occupation, settlement, and annexation, along with changing the demographic composition. The illegal Israeli settlements and the system associated with them are based actually on a dual process. On one hand, the forced displacement of Palestinians and the confiscation of their lands, and on the other hand, the transfer of Israeli settlers and the construction and expansion of settlements on confiscated lands. International humanitarian law prohibits the forced displacement of the occupied people and the transfer of citizens of the occupying power to the occupied territories, as confirmed by Article 49 of the Fourth Geneva Convention, that provides for the protection of civilians in the time of war. Thus, forced displacement and transfer of citizens by the occupying power constitute grave violations under Article 147 of the aforementioned Convention. Indeed, the actual annexation of parts of the occupied Palestinian land is embodied through a continuous gradual process involving the implementation of many measures and actions that include, among others, settlements' size, infrastructure, and location, which indicate the purpose to make them sustainable. Israeli government plans and directives that allowed the establishment and expansion of settlements. The legislation that enacted a dual legal system in the occupied territories in favor of the settlers at the expense of the occupied people, including the Basic Law of 2018, aka Israel as the nation state of the Jewish people. Another example, public statements of Israeli officials demonstrate to the fact that the settlement and the system associated with them constitute a deliberate policy of obtaining a permanent presence for the annexation of the territories, and confirm that the actual annexation had already taken place. The guidelines and coalition agreements of the new Israeli occupation authorities, sworn in on the 29th of December 2022, in which they explicitly declare that the Jewish people have an exclusive and indisputable right to all areas of Israel, and undertake to strengthen and develop settlements throughout what they called the land of Israel, in the Galilee, the Negev, the West Bank, and in the occupied Syrian Golan, despite the confirmation by the United Nations Security Council Resolution 497 of 1981 that provides, and I quote, "The Israeli decision to impose its laws, jurisdiction and administration in the occupied Syrian Golan Heights is null and void and without international legal effect." End of quote. Mr. President, distinguished members of the Court, in 1980, the Israeli Knesset adopted the Basic Law on Jerusalem, which states that Jerusalem, whole and united, is the capital of Israel, effectively annexing the city in flagrant violation of international law and of the city's own international status. In response, the United Nations Security Council adopted Resolution number 478, which declared that, again I quote, "All legislative and administrative measures and actions taken by Israel, the occupying power, which have altered or purport to alter the character and status of the holy city of Jerusalem, and in particular the recent Basic Law on Jerusalem, are null and void and must be rescinded forthwith." Mr. President, since then, the Israeli occupation authorities have worked to consolidate further annexation instead of reversing it. I shall now talk about the legal consequences. Israel is obliged to immediately stop all its violations of its legal obligations in Jerusalem and all other occupied Palestinian territories. The cessation of such violations entails, inter alia, the dismantling of illegal structures, including settlements and the apartheid wall, the cancellation or the activation of all legislative and regulatory acts adopted by Israel with the aim of building illegal settlements and normalizing said system. Also, Israel is obliged to make reparation for the damage caused to individuals concerned through restitution and compensation. Regarding the legal consequences for third states, the United Nations General Assembly, in its resolution 77/25, called on all states, inter alia, first, not to recognize any alterations to the pre-1967 borders and to ensure that agreements with Israel do not imply recognition of Israeli sovereignty over the territories occupied by Israel in 1967. Second, not to provide aid or assistance to illegal settlement activities, specifically with settlements in the occupied Arab territories of Palestine and the Golan, in line with Security Council Resolution 465 of 1980. For the United Nations, the international organization, in particular the General Assembly and the Security Council, should consider the additional measures and binding international legitimacy tools stipulated in the Charter that are required to immediately end the illegal occupation and take the necessary measures to ensure the implementation of its relevant resolutions without any further delay. Your Honours, just as a reminder, today we are talking about a huge record of UN resolutions that Israel keeps violating. Actually, when it comes to the Arab-Israeli conflict, we are talking about 180 resolutions of the General Assembly and 227 resolutions of the Security Council. Mr. President, allow me now to move on to the part of the question regarding discriminatory legislations and measures. Since its inception, Israel has adopted various discriminatory legislations aimed to ensuring its control over the maximum geography with the minimum possible number of Palestinians. The United Nations Human Rights Council has described the Israeli discriminatory measures as, and I quote, a combination of movement restrictions consisting of the wall, checkpoints, a permit system that affects only the Palestinian population, and the application of a two-tier legal system that facilitated the establishment and consolidation of settlements and other violations and forms of institutional discrimination. End of quote. The United Nations General Assembly has always, and for many years, condemned in a large number of resolutions the discriminatory policies and practices of Israel, the occupying power, against the Palestinians as well as the Syrians in the occupied Syrian Arab Golan. These policies and practices include, according to these resolutions, killing and injuring civilians, arbitrary arrest and detention, in addition to forced displacement of civilians, transfer of settlers to the occupied Palestinian and Syrian territories, destruction and confiscation of civilian properties, and demolishing homes. Your Honors, in the devastated Gaza Strip, long before the 7th of October 2023, Israel practices racial discrimination towards the Palestinian population in the form of its ongoing blockade. The discriminatory nature of the blockade actually imposed on the Gaza Strip was recognized by the United Nations Committee on the Elimination of Racial Discrimination. This blockade was found to violate the Convention on the Elimination of Racial Discrimination. The actions of Israel are part of a large-scale, repressive, organized and systematic regime. Such actions have been identified as apartheid after thorough factual and legal examination by the UN Special Procedures and by various international organizations. Apartheid is most manifested in the occupied Palestinian territories, including Jerusalem, where illegally located settlers benefit from far-reaching privileges at the expense of the basic rights of the Palestinian people. For legal consequences, Israel is obliged to immediately repeal all legislations aimed at or leading to the maintenance and perpetuation of apartheid and racial discrimination against the Palestinian people. This includes the termination of its settlement activities, the cessation of all discriminatory policies and practices, along with due compensation to all those affected by these policies and practices, including Palestinian refugees. For third states, they must not recognize this illegal situation and must not provide any help or assistance in any way that may sustain and maintain this situation. For the United Nations, especially the General Assembly and the Security Council, the international organization should consider the additional measures required to end the apartheid system established by Israel and should take the necessary measures to ensure the implementation of its relevant resolutions without further delay. After this review, allow me, Mr. President, to present my country's legal position on the second question presented before the distinguished court in accordance with the relevant General Assembly resolution. It's about illegal status of occupation. The acts and practices of occupying powers are strictly regulated by international law and international humanitarian law. Article 49, paragraph 6 of the Fourth Geneva Convention stipulates that, and I quote, "The occupying power shall not deport or transfer parts of its civilian population to the territories it occupies." End of quote. While the occupying power is obliged under international law to administer the territory for the benefit of the people under its occupation, Israel administers the territory only for the benefit of its settlers, and even to ensure the sustainability of the illegal occupation of others' land. While annexations or claims of sovereignty over territories under the interim administrative authorities of the occupying power are strictly prohibited, Israel has sought to exercise fait accompli sovereignty over Jerusalem and the occupied Arab territories. Mr. President, members, distinguished members of this honourable court, we believe in the first place that the Israeli occupation in and of itself should be considered absolutely illegal, and that we should not be satisfied with only and merely describing its practices and policies. Allow me now to move to the legal consequences. The legal consequences constitute Israeli commitment to an immediate and unconditional end to its occupation of the Arab territories in Palestine and the rest of the occupied Arab territories, including the Syrian Arab Golan, in addition to providing compensation to all those affected. For third states, it is imperative to commit to support all efforts exerted to end the illegal occupation without delay, and to refrain from any actions that contribute to maintaining the illegal situation. For the United Nations, in particular the General Assembly and the Security Council, it should consider the additional measures and binding international legitimacy tools stipulated in the Charter that are required to ensure the implementation of the relevant resolutions without any further delay, including the immediate and unconditional end to the Israeli occupation of the occupied Arab territories in Palestine and the Syrian Golan. The Honourable Judges, the Syrian Arab Republic affirms the principle that states shall not obtain legal rights from unilateral acts that do not comply with international law. Syria also re-emphasizes the temporary nature of the occupation, and that even if it is a fait accompli, this does not and will not give the occupying power the right to acquire sovereignty over the occupied territories, no matter how long this brutal occupation lasts. Syria reiterates that the stability of the Middle East and the credibility of the United Nations system, including the esteemed court, require taking measures to ensure the implementation of all relevant international resolutions to end the Israeli occupation of all occupied Arab territories in accordance with the relevant United Nations resolutions. Mr. President, esteemed members of the court today, in this case, does not create new rights, but rather reveals rights that are violated by Israel every day since 1948. Israel is not only committing the horrendous act that we have just mentioned, but we are currently witnessing Israel committing genocide in the occupied Gaza Strip, attacking Syria, attacking Lebanon, and committing war crimes and crimes against humanity. In fact, one of the reasons for Israel's consideration of itself as being above the law is that it has been carrying out illegal occupation and committing crimes for 75 years without facing accountability or any sort of consequences. Today, it has become imperative for all states to convince or to show Israel, the occupying power, by all possible legal means that it does not have a green light to annex more occupied territories, expel their indigenous people, and build more illegal settlements. Most importantly, convincing and showing Israel that there will be no peace, no security or stability for all and equal without ending the occupation and establishing a viable and sustainable Palestinian state that possesses full competence and authorities like all member states of international community. The continuance of these violations means more Israeli escalations vis-à-vis the Palestinian people exercising their legitimate right to resist the occupation. Many decades have passed, and the suffering of the Palestinian, Syrian, and Lebanese peoples under the Israeli occupation continues, mainly due to the absence of a decisive and credible political will that is keen to implement the provisions of international law. Your Honours, today, and for all these reasons, and for the sake of genuine peace and unshakable justice, we look forward to the role of jurists who took it upon themselves to equally uphold the provisions of the law in order to contribute to achieving peace and justice to those people suffering under the most violent, most tyrannous, and most oppressive form of occupation in the history of humanity. Thank you, Mr. President. Thank you, distinguished members of the Court.
I thank the delegation of the Syrian Arab Republic for its presentation.
I invite the next participating delegation, that's Tunisia, to address the Court and call Professor Slim Lagmani to the podium. You have the floor, sir.
Monsieur le Président.
Mr. President, distinguished members of the Court, it is an honour for me to appear before your esteemed Court to set out Tunisia's point of view on the request for the advisory opinion before you. This is a request for an opinion which deals with the oldest and most unbearable injustice, namely that of the Palestinian people. In December 2022, Tunisia voted in favour of Resolution 77247 because it was then and remains now convinced that an impartial and lucid legal opinion given in response to the questions posed by the General Assembly is necessary not only for the General Assembly and the United Nations, but even more so for the international community as a whole. Regarding questions relative to the jurisdiction and discretion, we are of the opinion that those arguments which led the Court in its advisory opinion on the legal consequences of the building of a wall in occupied Palestinian territory to conclude, I quote you, not only has the Court jurisdiction to give an opinion on the question posed to it by the General Assembly, but there is no compelling reason for the Court to use its discretion to not do so. End of quotation. We are of the opinion that these arguments are valid for the instant request for opinion. There is, however, a specific argument in favour of the eminently legal character of the questions put in the instant request, and they're worthy of development. The reference by the General Assembly successively to occupation, to colonisation, annexation, shows that it is the law which is at the centre of the questions asked. Indeed, given the policies and practices of Israel in the OPT, we need to respond to the next question. Can we still speak only of an occupation, understood as placing a territory under the authority of an enemy army? Don't you think that really today this is a euphemism? Hasn't Israel gone far further than just merely annexing de jure or de facto Palestinian territories by adopting laws and measures discriminatory?
Une guerre d'anéantissement. Et en allant au-delà, dans quelle catégorie juridique la présence illégale d'Israël dans les territoires palestiniens doit-elle être classée? Contrairement à ce que l'on a pu prétendre, la réponse de la Cour, donnée à titre consultatif à une telle interrogation, ne ferait en aucune manière obstacle à un règlement politique négocié du conflit. Bien au contraire, il est utile aux négociations que les négociateurs soient éclairés par un tiers impartial sur ce que, en droit, ils sont en mesure d'exiger et sur ce à quoi, en droit, ils peuvent ou doivent renoncer. Mais voyons d'abord de quelle violation il est question, nous verrons ensuite leurs conséquences juridiques. Monsieur le Président, Mesdames et Messieurs les juges de la Cour, vous disposez de tous les éléments qui établissent la violation continue par Israël du droit du peuple palestinien à disposer de lui-même, de la mise hors la loi de l'agression, de l'interdiction de l'acquisition des territoires par la force, des violations à la fois graves et persistantes des droits humains des Palestiniens, ainsi que des règles dont la Cour a dit qu'elles sont intransgressibles du droit international humanitaire. Parmi ces éléments, nous référons en particulier à ceux établis par les décisions du Conseil de sécurité qu'on ne peut accuser d'avoir un parti pris contre Israël, et par la Cour dont il serait incongru de douter de l'indépendance dans son avis du 9 juillet 2004. L'ensemble des principes et règles violés figure dans la liste non exhaustive des normes impératives du droit international général annexée par la Commission du droit international à son projet de conclusion relative à la détermination et aux conséquences juridiques des normes de jus cogens. La Cour, quant à elle, a qualifié certaines des normes violées de règles de jus cogens. Il en a été ainsi de l'interdiction de la torture et des crimes constituant des infractions graves aux conventions de Genève de 1949 et au protocole additionnel à ces conventions. D'autres ont été qualifiés de droits ou d'obligations erga omnes, de principes cardinaux, de principes intransgressibles, de principes essentiels du droit international contemporain, ou encore de règles dictées par des considérations élémentaires d'humanité. Nous ne pouvons, dans les limites imparties au présent exposé, analyser l'ensemble de ces violations. Il nous suffira de montrer que l'occupation des territoires palestiniens, considérée dans la durée et comme un tout, a pour finalité ultime la négation du droit du peuple palestinien à disposer de lui-même, l'acquisition de son territoire par la force. Et pour réaliser cette fin, Israël n'a pas hésité à choisir le pire des moyens, le génocide du peuple palestinien. Donc d'abord, la négation du droit du peuple palestinien à disposer de lui-même. À l'issue de la Première Guerre mondiale, la Palestine a été placée sous mandat A britannique. En vertu de l'article 22, paragraphe 4 du Pacte de la Société des Nations, ce mandat concerne, je cite, certaines communautés qui appartenaient autrefois à l'Empire ottoman, ce qui est le cas de la Palestine. Ces communautés, poursuit l'article, ont atteint un degré de développement tel que leur existence comme nations indépendantes peut être reconnue provisoirement. La Société des Nations considérait donc la Palestine comme une nation, un peuple, dirions-nous aujourd'hui. Et le mandat devait, à son terme, déboucher sur l'indépendance définitive de la Palestine, et ce, sur la totalité du territoire du mandat. Tout au long de ce mandat, le Royaume-Uni a mis en œuvre la déclaration Balfour, intégrée dans le mandat britannique sur la Palestine. La déclaration prévoyait non pas la création d'un État juif, mais, je cite, l'établissement en Palestine d'un foyer national pour les Juifs. Ce processus a abouti à la résolution 181, deuxième session de l'Assemblée générale du 29 novembre 1947, qui recommandait de placer la ville de Jérusalem sous un régime international spécial, ainsi qu'un plan de partage accordant à l'État juif 56,47% du territoire de la Palestine mandataire. Cette recommandation, qui méconnaissait la raison d'être du mandat, menait la Palestine vers son indépendance définitive sur la totalité du territoire du mandat, devait, pour produire des effets juridiques, être acceptée par les deux parties. La partie juive l'accepta, mais les Palestiniens et les États arabes de la région la refusèrent. La partie juive s'empressa pourtant à proclamer son État. Il s'ensuivit la guerre de 48-49 qui aboutit à un amoindrissement de l'ordre de 23% de l'espace concédé à l'État palestinien par la résolution 181 et à l'exil de 750 000 Palestiniens. L'effet de cette guerre et des rapports de force qui se sont établis à la suite de la Seconde Guerre mondiale furent, dans un premier temps, une régression. La reconnaissance de l'existence d'un peuple palestinien et de son droit à disposer de lui-même par les organes politiques des Nations Unies a été en effet lente à venir. Avec votre permission, Monsieur le Président. Dans un premier temps, les Palestiniens ne furent considérés que comme des réfugiés. Et il faudra attendre le 10 décembre 1969 pour que l'Assemblée générale reconnaisse, je cite, les droits inaliénables du peuple de Palestine. Le 30 novembre 1970, elle condamnera, je cite, les gouvernements qui refusent le droit à l'autodétermination aux peuples auxquels on a reconnu ce droit, notamment les peuples d'Afrique australe et de Palestine. Elle reconnaîtra la légitimité de la lutte que mènent les peuples assujettis à une domination coloniale et étrangère et auxquels on a reconnu le droit à disposer d'eux-mêmes pour recouvrer ce droit par tous les moyens dont ils disposent. Fin de citation. La reconnaissance solennelle du peuple palestinien interviendra le 22 novembre 1974. L'Assemblée générale affirmera, je cite, les droits inaliénables du peuple palestinien, y compris le droit à l'autodétermination sans ingérence extérieure et le droit à l'indépendance et à la souveraineté. Le Conseil de sécurité sera encore plus lent à intégrer dans ses résolutions l'expression peuple palestinien. C'est dans sa résolution 605 du 22 décembre 1987 que le Conseil affirmera à notre connaissance pour la première fois l'existence d'un peuple palestinien. Il y déplore vivement, je cite, les politiques et pratiques d'Israël, puissance occupante, qui violent les droits de l'homme du peuple palestinien dans les territoires occupés. Dans la résolution 672-1990, le Conseil reconnaîtra les droits politiques légitimes du peuple palestinien. Et votre Cour tirera dans son avis du 9 juillet 2004 les conséquences de cette évolution en affirmant « l'existence d'un peuple palestinien ne saurait plus faire débat ». La reconnaissance de l'existence d'un peuple emporte la reconnaissance de son droit à l'égalité des droits, à la création d'un État souverain et indépendant, à la libération et à l'intégrité de son territoire. Or, à l'évidence, le peuple palestinien est privé par la force de la jouissance de l'ensemble de ses droits. C'est ce à quoi la Cour conclura le 9 juillet 2004. Je la cite, « L'obligation erga omnes de respecter le droit du peuple palestinien à l'autodétermination est violée par Israël. » Mais ce n'est pas seulement son droit à l'autodétermination que le peuple palestinien est privé. Il est atteint dans son existence même. Monsieur le Président, Mesdames et Messieurs les membres de la Cour, le génocide est, dit-on, le crime des crimes. Et l'on emploie souvent cette expression pour signifier que c'est le plus grave des crimes internationaux. Nous l'employons ici pour déterminer l'incidence de ces actes illicites sur le statut juridique de l'occupation, objet de la question 2 que vous a posée l'Assemblée générale. Nous savons que la Cour est saisie au contentieux de la question du génocide, mais il est impératif, il est nécessaire de l'aborder ici également, parce que le génocide du peuple palestinien en vue de l'acquisition de son territoire et, du point de vue de la Tunisie, le statut juridique de l'occupation. L'interdiction du génocide est incontestablement une norme de jus cogens. Le crime de génocide est défini par l'article 2 de la Convention pour la prévention et la répression du crime de génocide. Je cite, « Aux fins du présent statut, on entend par crime de génocide l'un quelconque des actes ci-après commis dans l'intention de détruire en tout ou en partie un groupe national, ethnique, racial ou religieux comme tel. Petit a, meurtre de membres du groupe. Petit b, atteinte grave à l'intégrité physique ou mentale de membres du groupe. Petit c, soumission intentionnelle du groupe à des conditions d'existence devant entraîner sa destruction physique totale ou partielle. Petit d, mesure visant à entraver les naissances au sein du groupe. Et petit e, transfert forcé d'enfants d'un groupe, du groupe à un autre groupe. Il ne fait aucun doute que le peuple palestinien constitue un groupe national au sens de l'article 2 de la Convention. Comment ne le serait-il pas alors qu'il constitue un peuple et qu'à ce titre, il est titulaire du droit à l'autodétermination. Il ne fait aucun doute non plus que les actes mentionnés au paragraphe A, B, C et D ont eu lieu et ont encore lieu en ce moment. Le monde entier a été et est encore témoin de la guerre contre Gaza, la 5e depuis 2007, de la violation systématique et massive des droits humains fondamentaux et des normes du droit international humanitaire dont la Cour a dit qu'elles sont intransgressibles. À cet égard, il convient de rappeler que le génocide ne suppose pas l'extermination de la totalité des membres du groupe protégé. La Cour a considéré dans son arrêt, votre Cour a considéré dans son arrêt du 26 février 2007 que, je cite, « l'intention génocidaire doit être de détruire au moins une partie substantielle du groupe en question ». Fin de citation. Et de fait, la Cour a constaté dans son ordonnance du 26 janvier 2024 que, je cite, « les Palestiniens de la bande de Gaza forment une partie substantielle du groupe protégé ». Auparavant, le monde a été également témoin du blocus terrestre, maritime, aérien imposé à Gaza depuis 2007, de l'usage excessif de la force par l'armée et les forces de sécurité dans les territoires occupés, occasionnant morts et blessés parmi les civils palestiniens, des actes de violence, de harcèlement commis par les colons armés envers les civils palestiniens, et en particulier des enfants, de la destruction de biens, de la confiscation de terres, notamment en guise de châtiment, de châtiments collectifs, des expulsions, des déplacements forcés de civils, notamment les tentatives de transfert forcés de familles bédouines, du maintien en détention de milliers de Palestiniens, dont un grand nombre de femmes et d'enfants, ainsi que de représentants élus, du recours fréquent à un internement administratif d'une durée excessive, sans chef d'inculpation, sans la garantie d'une procédure régulière, et des mauvais traitements qui, de l'avis d'observateurs impartiaux, vont jusqu'à la torture. Du bouclage de certaines zones, de la mise en place de centaines d'obstacles à la circulation, de postes de contrôle, d'un régime de permis qui entrave la liberté de circulation des personnes et des biens, et notamment des biens médicaux et humanitaires. Mais il ne suffit pas d'établir l'élément matériel pour prouver le génocide. La spécificité de ce crime réside dans son élément intentionnel particulier. L'intention relevant du fort intérieur est certes toujours difficile à prouver, mais une telle preuve n'est pas impossible si on établit l'existence d'une politique génocidaire, c'est-à-dire d'une option prise collectivement ou individuellement par des autorités qui ont le pouvoir de décision et d'exécution, visant à détruire les Palestiniens en tant que groupe national. Une telle politique existe. Elle est attestée par les textes juridiques israéliens, par les déclarations de responsables politiques du plus haut niveau et par le caractère systématique, coordonné des pratiques et des mesures constatées. Rappelons en particulier l'agression de 1967 et depuis le refus de se retirer des territoires occupés, qui montre qu'Israël a occupé ces territoires pour s'y installer définitivement. L'annexion de jure de Jérusalem, l'annexion de facto de la Cisjordanie, notamment par sa colonisation, qui vise à terme à établir un fait accompli: la Cisjordanie n'est pas palestinienne. La loi fondamentale, mon collègue syrien en parlait tout à l'heure, Israël en tant qu'État national du peuple juif, qui, dans son article 1er, définit la terre d'Israël comme étant, je cite, la patrie historique du peuple juif, dans laquelle l'État d'Israël a été créé. Fin de citation. En référant ainsi, en ce qui concerne cette terre, non pas à la légalité internationale, mais à un récit identitaire qui intègre toute la Palestine mandataire. Et plus, le même article 1er dispose que, je cite, le droit d'exercer l'autodétermination nationale au sein de l'État d'Israël est exclusif au peuple juif, donnant ainsi valeur constitutionnelle à la négation même du droit du peuple palestinien à l'autodétermination. Citons également l'article 7 qui dispose: l'État considère que les colonies juives, que le développement des colonies juives est une valeur nationale et agira pour encourager et promouvoir leur création et leur renforcement. Rappelons aussi les principes directeurs de l'accord de coalition de l'actuel gouvernement israélien, qui a prêté serment le 29 décembre 2022. Le premier de ce principe proclame expressément que, je cite, le peuple juif a un droit exclusif et incontestable sur toutes les zones de la terre d'Israël, et engage le gouvernement à promouvoir et développer les colonies dans toutes les parties de la terre d'Israël, en Galilée, dans le Negev, dans le Golan, en Judée et en Samarie. Fin de citation. Le 11e principe directeur affirme que le gouvernement œuvrera à consolider le statut de Jérusalem. Rappelons également les déclarations des dirigeants d'Israël. On se limitera ici à deux, à donner à titre d'exemple. La première est celle du ministre des Finances israélien en date du 19 mars 2023. il n'y a pas de Palestiniens, car il n'y a pas de peuple palestinien. La seconde est la déclaration du Premier ministre israélien. Je le cite, « Je ne ferai aucun compromis sur le plein contrôle qui devra être conservé par Israël en ce qui concerne la sécurité sur tout le territoire situé à l'ouest du fleuve Jourdain. » Il ressort clairement de ces textes et déclarations qu'Israël considère que tout le territoire de la Palestine mandataire et plus est sien et qu'il n'y a pas de peuple palestinien. Tout ce qui précède montre, Monsieur le Président, Mesdames et Messieurs les juges de la Cour, l'existence d'une politique systématique, c'est-à-dire une intention et une volonté claire de détruire les Palestiniens en tant que groupe national, ayant le droit à l'autodétermination et à l'indépendance, et de réduire les rescapés à un ensemble de réfugiés apatrides. Voyons maintenant les conséquences juridiques qui découlent de ces violations. Elles peuvent être classées en deux catégories. Les conséquences particulières des violations graves des normes impératives du droit international général, d'une part, et les conséquences spécifiques de la violation de l'interdiction du génocide, d'autre part. La Commission du droit international a attribué des conséquences particulières aux violations graves des normes de jus cogens. Et elle a défini ce qu'elle entend par violation grave. Et grave, une violation si elle dénote de la part de l'État responsable un manquement flagrant ou systématique à l'exécution de cette obligation. Fin de citation. Les violations des normes de jus cogens commises par Israël sont à la fois flagrantes et systématiques. Flagrant se dit de ce qui paraît évident aux yeux de tous. N'est-il pas évident aux yeux de tous qu'Israël occupe les territoires palestiniens, qu'il colonise ces territoires, qu'il a annexé Jérusalem, que dans la guerre d'agression qu'il mène contre Gaza, il méconnaît et revendique la méconnaissance des principes de distinction et de proportionnalité, qu'il a volontairement ciblé des lieux et des personnes protégées. Systématique se dit de ce qui est fait avec méthode et sans défaillance, de ce qui procède d'un ordre déterminé à l'avance et de ce qui est délibéré. Ne ressort-il pas des politiques et des pratiques d'Israël qu'il y a un ordre déterminé à l'avance, un plan ourdi dont le but final est de détruire les Palestiniens en tant que peuple, de les réduire à une poussière d'individus, et qu'Israël n'a jamais cessé d'œuvrer pour le réaliser. Il résulte des violations graves des normes impératives du droit international général les conséquences suivantes. L'État responsable ne peut pas se prévaloir des circonstances excluant la responsabilité. Israël ne peut se prévaloir ni de la légitime défense, ni de la force majeure, ni de la détresse, ni de l'état de nécessité pour exclure sa responsabilité. Et il n'est pas non plus en droit de recourir aux contre-mesures. En ce qui concerne les autres États, les normes de jus cogens créent des obligations erga omnes, à l'égard desquelles tous les États ont un intérêt juridique. En particulier, tous les États ont le devoir de coopérer pour mettre fin, par des moyens licites, aux violations commises par Israël. Tous les États ont le devoir de reconnaître comme illicites les situations créées par l'occupation des territoires palestiniens et de s'abstenir de tous actes qui constitueraient une aide ou une assistance à cet égard. Tous les États, et pas seulement les États lésés, sont en droit d'invoquer la responsabilité d'Israël. Ils peuvent exiger d'Israël la cessation de ces violations et des assurances et garantie de non-répétition, ainsi que l'exécution de l'obligation de réparation. La violation de l'interdiction du génocide emporte toutes les conséquences particulières de la violation des normes de jus cogens. Elle emporte également les conséquences spécifiques prévues par la Convention pour la prévention et la répression du crime de génocide et par le statut de Rome de la Cour pénale internationale pour tous les États qui y sont partis. Ces conséquences spécifiques sont les suivantes. D'abord, l'établissement d'une compétence universelle. À cette fin, les États partis doivent notamment prévoir des sanctions pénales efficaces frappant les personnes coupables de génocide ou de l'un quelconque des autres actes incriminés par l'article 3 de la Convention de 1948. Ensuite, le droit pour toute partie à la Convention de 1948 de saisir les organes compétents de l'Organisation des Nations Unies afin que ceux-ci prennent des mesures appropriées pour la prévention et la répression des actes de génocide. En troisième lieu, le droit pour toute partie à la Convention de 1948 de saisir la Cour par requête unilatérale de tout différend relatif à la responsabilité d'Israël en matière de génocide ou de l'un quelconque des autres actes énumérés par l'article 3. C'est ce qu'a fait l'État d'Afrique du Sud. En quatrième lieu, le droit pour tout État parti ou pour tout État qui a accepté la compétence de la Cour pénale internationale, conformément à l'article 12, paragraphe 3 du statut de Rome, de saisir la Cour s'il a des raisons sérieuses de croire qu'un crime de génocide a été commis sur son territoire. C'est ce qu'a fait l'État de Palestine. Enfin, le droit pour tout État parti au statut de Rome de déférer au procureur de la Cour pénale internationale la situation en Palestine et de le prier d'enquêter sur la situation. C'est ce que le 17 novembre 2023 ont fait 5 États partis, l'Afrique du Sud, le Bangladesh, la Bolivie, les Comores et Djibouti. Nous conclurons notre propos par l'exposé des conséquences juridiques qui découlent pour l'Organisation des Nations Unies du statut juridique de l'occupation tel que nous l'avons déterminé. À cet égard, nous ne pouvons que paraphraser les conséquences dégagées par votre Cour dans son avis de 2004. L'Organisation des Nations Unies, et spécialement l'Assemblée générale et le Conseil de sécurité, doivent examiner quelles nouvelles mesures doivent être prises afin de mettre un terme à l'occupation des territoires palestiniens et aux violations graves et persistantes du droit impératif général qui y sont commises. Monsieur le Président, Mesdames et Messieurs les juges de la Cour, je vous remercie de votre attention.
Je remercie la délégation de la Tunisie pour son exposé qui met un terme à l'audience de cet après-midi. La Cour se réunira à nouveau le lundi 26 février à 10 h pour entendre la Turquie, la Gambie, la Ligue des États arabes, l'Organisation de la coopération islamique et l'Union africaine. L'audience est levée.